know. You got to run it tight like the speaker does. Did that just kill my bill? In the drawer.
Okay, we're going to maybe go ahead because we understand, the committee understands there are quite a few people in other committees presenting bills for some reason. I don't know why they wouldn't just present all of their bills here. But having said that, they care about other things, which is shameful. It's the House Judiciary Committee, and now I'm on tape saying that, on February the 14th, Valentine's Day. Where else would you rather be? Thank you. 2023. We only have 4 bills. We have about 60 witnesses, though, so we're going to try and get going here and keep moving. First is a very first time presenting a bill before this committee, Delegate Boucher, who is bringing House Bill 387. So why don't we hear from him? I think it's just you, so let's hear from you.
Yes, sir. Thank you very much. In the spirit of Valentine's Day, I want to tell everyone how much I love them, and especially the chairman. I got to soften the target, as the military would say, before I advance the infantry. This bill is very simple. This is my training wheels bill. All I will be doing is inserting 2 words, or forgery, into an existing code, Article Courts and Judicial Proceedings 10-905, which leads off as evidence is admissible to prove the interest of a witness in any proceeding or the fact of the witness's conviction of an infamous crime. The line I want to adjust states evidence that a witness has been convicted of perjury or forgery shall be admitted for the purpose of attacking the credibility of the witness regardless of the date of conviction. And this is to create comprehensive legislation that simply codifies and clarifies pre-existing law by explicitly stating forgery. This ensures the counsel knows the exact offenses that can be used to impeach a witness's testimony and eliminates the ambiguity of existing law. Furthermore, this legislation ensures that the integrity of the court is not compromised by false testimony. Legally, perjury is no different than forgery in the eyes of the court. And the reason I say that is, whether someone commits perjury orally or they forge someone's name, they are bearing false witness. So the purpose of this law is to ensure that someone does not take the stand, having been convicted of perjury, and improperly sway the judgment of the court, and also sway the verdict of a jury. Because unless I think sometimes things that are explicitly spelled in the law, a juror might not comprehend the importance of forgery as a conviction, because they say infamous crime. How many people have forgery come to the top of their head when they hear infamous crime? You think of murder, rape, armed robbery. You tend to overlook the importance of explicitly stating forgery. So I've listed that in this bill. I'll state that the Maryland State's Attorney Coordinator has not taken a position against this, and he's a very wise man, so I think that's a plus. I'm not on the wrong side of them. Also, the Administrative Office of the Court stated that the Judiciary's Legislative Committee reviewed the bill last week and determined to take no position on this bill as they believe it is a legislative prerogative. We appreciate you reaching out to us about this bill and your commitment to protecting the integrity of the court. And I think that's basically what this bill is about, and I think that'll sum it up.
Delegate Boucher, did you just indicate that the judiciary actually sent a letter that said that we can do something? That's what you said?
Well, hold on, let me read this again. Maybe I missed
I'm kind of flummoxed. I don't know what to do.
Let me read this again, all right? The Judiciary's Legislative Committee reviewed the bill last week and determined to take no position on the bill as they believe it is legislative prerogative. I don't know what happened to me, but I'll count my blessings every day.
Does the committee need a moment? Do we need All right. Are there questions for the delegate?
I figures John would come at me.
Delegate Williams has an important question.
There you go.
I'm just joking.
right, are there real questions for the witness?
That it?
That's it. Seeing none. Thank you very much. That
Thank
concludes
you.
the testimony on House Bill 387.
Hey, see what softening the target does? I didn't give out candy, though. Something else.
Speaking of the person who passed out candy, House Bill 362. Now, Delegate Simpson. Who passed this out? Oh, look, Delegate Simpson. We will hear from you, Elizabeth Hilliard. Jake Burdett. Oh, it's virtual. Do we have Mr. Burdett? Not yet. I know we've heard from him in previous years. This is the one you had once before, right? Come on up. Come on up. Yeah, that's right.
I like friends.
3 minutes to the delegate, 2 minutes for Ms. Hilliard. That'll be fine. Go ahead.
Alrighty. So you all should be, it's Valentine's Day, so I'm asking you all to be my Valentine. Thank you, Chair Clippinger, Vice Chair Moon, especially for giving me this lovely bill, and fellow members of the Judiciary Committee, or my Valentines for today. I hope you will give a favorable report for House Bill 362, the intercepted communications penalty. This was previously introduced in last year, 22, as House Bill 272, and it flew right through us, went to the Senate, and, well, shocked. It didn't make it. So we're hoping that we're going to get it through at this point in time. I think we would all agree most people would be extremely shocked to learn that they could not record someone verbally in Maryland, that they would assume that they were able to do such, especially with all the social media and everything that we see out there. This is important to me. I did jump on it that I was willing to take this as a domestic violence survivor. Many things happen that other people don't see or hear. The only thing about this bill, it doesn't repeal it or anything. It just makes it, instead of being a felony, it makes it a misdemeanor. And I think this is very important, especially for individuals, who, for safety reasons or, needing to prove that they are in a bad situation. So especially, victims of gender violence. So I humbly request that you provide a favorable report for House Bill 362, intercepted communications penalty. Thank you very much.
Thank you, Chair, Vice Chair, members of the committee, Elizabeth Hilliard, representing the Office of the Public Defender. Us too. We full-throatedly support the effort to reduce any convictions from a felony to a misdemeanor, especially when they're in instances that are preserving someone's safety. So we thank Delegate Simpson, and it does not shock me that perhaps Delegate Moon also had a say in this, cleaning up the code. We thank you for bringing this bill, and we're in full support of it, and we hope that the Senate can agree with us this session.
Well, here's for hoping. So, are there questions for the panels? Delegate Kaufman to begin.
Yes, thank you. My question is for the Delegate Simpson. I really appreciate this issue. I really appreciate you bringing this forward, my friend. I understand your concern about crime of, violence and safety and different things, but maybe this is the wrong question to ask on Valentine's Day, but I'll ask about it too. Would this also apply to somebody who catches their husband or wife cheating? Would it be a misdemeanor for them too?
It would be, it would be anyone who's recording somebody else. It would be a misdemeanor instead of a felony for them to record that conversation.
Okay, so my married friends need to be very careful. Thank you.
Again, happy Valentine's Day to everyone.
Right.
We'll go Delegate Munoz and Delegate Tolles. Delegate Munoz.
Thank you, Mr. Chair. Delegate, I have a question. I heard you say that this bill flew through, was it both committee and the House last session? And are you aware if it had any bipartisan support at all?
I am not aware.
You're not aware of the votes?
No, I actually am not aware of it won't show up on my floor system because I'm new and wasn't here.
Okay, so on mine, I don't see, I'm trying to find someone, a Republican who voted for it on the floor, and I'm not able to. And I see 6 of us voted against it last time in committee. So have you spoken to any of those colleagues about their opposition to the bill or why they might oppose it?
No, as I said, I wasn't aware that there was opposition to the bill since it was passed through the House is what I was looking at.
Thanks so much.
You're welcome.
Quick question. So, so you no longer can get a felony, you get a misdemeanor if you record somebody and they don't know about it?
Correct.
Okay, thank you.
Thank you, Mr. Chair. And thank you for bringing this bill back and giving it a second try in the Senate, hopefully. Can you just tell us some of the consequences of becoming a felon in Maryland, what that means for someone, and whether those consequences are appropriate for someone whose sole offense was to break out their phone and make a recording?
It could make it very difficult for them to find a job and employment and other things that a misdemeanor would not provide. I mean, it still would be a misdemeanor, but they wouldn't have that felony making it difficult, even for housing. I mean, we see that. We know that can be an issue.
I will add a couple. Student loan assistance, the finding a job with specific city councils, city, counties, or unionized jobs occasionally based on felony convictions. There is also presumptions and mandatory sentences that can kick in on any subsequent penalties if there's a prior felony, and it can also impact food assistance and other benefits from the state.
And Ms. Hilliard, can you tell us what that offense, unauthorized taping, what are the other felonies that lines up with? Like, what other types of offenses are felonies in Maryland?
I can't because I don't read the code for fun like you do. No. I am not, to be completely honest, I'm not quite sure I understand the question.
Can I
apologize.
help the vice chair just a little bit? Yeah. Is murder a felony?
Oh, yes.
Okay, go back to his question now.
Or rape, or, right.
I apologize. Maryland actually has a very complicated felony versus misdemeanor distinction. I was previously barred in Oregon and practiced in Oregon, where the distinction is based on timing. 1 year and a day, misdemeanor, below that, and then above that is a felony. Here it is more ambiguous, but a felony tends to be a more...
You're going too far into the weeds. I think the chair saw where I was going with this. Yes.
Okay, right.
Thank you very much. And last question. Were you guys aware that one of the catalyzing incidents to raise why this is an inappropriate penalty was a college student who got charged with a felony for using their cell phone in a taping of a meeting with a member of Congress from Maryland?
Mm-hmm.
That was a yes or no
Yes.
question. Thank you. Okay.
I am aware of that.
All
I
right.
thought we were going to have the testimony of such.
Apparently he's preoccupied. But thank you very much again for bringing the bill.
Okay,
Are
absolutely.
there further questions from this panel, for this panel, of this panel? Delegate Conaway, who is angry that I didn't see him right away.
3 questions ago. Thank you, Mr. Chair. How you doing? Hello, good afternoon.
Happy
delegate.
Valentine's Day.
Yeah, thank you, delegate, and thank you, witness, for coming in. So, in introducing your bill, you omitted from saying without permission. So, in the case that we might hear about with the congressman, you think that the congressman should be able to be recorded without his permission, maybe in a private meeting?
Yes, I do. Actually, I do believe elected officials should be, know that it's possible. But this isn't, this is a it doesn't change that they would be charged. It just makes it, instead of being the same classification of murder, as being a misdemeanor.
It also doesn't reduce the penalties available.
Right, it just changes one word.
Okay, so in your introduction, were you saying that a person who might be a victim of gender violence, who's recording someone, might be charged and convicted of this unauthorized videotaping or recording of information?
Absolutely, it has happened.
How many times has it happened?
I don't know how many specifically, but it does happen, in which the other partner has, you didn't have my permission to make this recording.
Now you're saying other partners, so when one partner makes secret videotapes of another partner, and the partner finds out about it, and then they break up, then these charges can be brought against the partner who maybe was making the video recordings? That's what you're saying?
We're talking about conversations that they've had.
You said
Video
part-
is actually interesting enough. Video is already allowed, I believe. It's just.
Well,
that
I
it's
don't
the-
know, because it says electronic communication, so is electronic communication just audio, or is it audio and video?
Well, again, the bill doesn't remove any charges. It just reclassifies.
Right, I didn't ask that. I asked, was the electronic communication audio or audio and video? Since we were talking about recording with cell phones, and that can be audio, or that can be audio and video.
I
Is that
think you
correct?
are allowed to take pictures and things like that. It's the
A picture is
audio.
different- A picture is different than a
Right.
video. A video is a motion picture versus a picture is a still frame.
Yeah, I believe it's the issue of the conversation, the audio, but any video is going to have both.
Okay, thank you very much.
The person that was being referred to, Mr. Burdett, has joined us and was signed up to testify, is still signed up to testify. So we're going to hear from him for 2 minutes right now, and then we'll take any further questions and go from there. So Mr. Burdett, please, for 2 minutes.
Hey, good afternoon, Chair Cloninger and members of the House Judiciary Committee. My name is Jake Burdett, and I'm testifying today once again in support of Delegate Simpson's bill HB 362, which would make Maryland's interception of communications penalties a misdemeanor rather than a felony. This is a bill that is very important to me personally because Maryland's current archaic and overly punitive wiretapping laws have negatively impacted my life in a major way. Specifically, I was in a very high-profile and controversial case in 2018 during my time in college at Salisbury University, where notorious Maryland's against me for live streaming a protest at his constituent office without the consent of his staffers. Despite widespread bad press resulting from this authoritarian move, I was still facing a potential 10 years in jail for this, as well as 2 felony charges. Although I was able to avoid any jail time by taking a probation before judgment plea deal, and I was not actually convicted of any felonies, just having the felony charge on my record at all has continued to follow me around for my young adult life and make it very difficult for me to find meaningful employment, and has also served as a scarlet letter for my reputation. Unfortunately, there's a lot of stigma around the label felon, as I've had to learn the hard way. Many employers just outright reject any potential applicants based solely on having any felonies on their background, and no matter how serious the felony charge. And because of these felony charges, I face serious hiring discrimination from employer after employer for jobs I was actually qualified for. And as a result, I had no choice but to work in an Amazon warehouse during the height of COVID, as they are one of few employers I could find that did not do background checks. It's a shame that the label felon carries so much negative weight, and since it does, I think the judiciary should recognize that and decrease the penalty to a misdemeanor. Thank you.
Okay, so now, again, questions out for the complete panel. Delegate Grammer.
Thank you, Mr. Chair. In the state of Maryland, if you commit a felony, do you lose your gun rights?
I don't know, but
Yes.
probably, yeah.
Yes.
Yes.
Whereas a misdemeanor, you don't, I believe.
Okay. Second question, and I'm not up to date on the definition as it applies. You have a Ring doorbell or some kind of security measure. You're clearly not intentionally recording. How does state law govern that situation?
Thank you for that question, Delegate. And what I will say is I just found the definition of electronic communication, and it requires the transfer of signs, signals, writing, images, sound, data, or intelligence in whole or part by wire, radio, electromagnetic, photoelectronic, or phototopical systems. And so I think there the key would be the transfer. So if your Ring doorbell is just something that you're observing, you're not transferring it anywhere, and you are not taking that opportunity to do that. Whereas if you were actively recording and then use it, that would require a transfer.
So if I had a Ring doorbell and it was a particularly egregious situation, someone was trying to use it for a protective order, that's something that's not permissible?
No, I think that if you were trying to introduce it and you were trying to, then you would be no longer subject to a felony should this law pass.
Okay.
I think the key is the unknowingly, because obviously usually a Ring doorbell, you see it.
I know it's a little bit off topic, but I
Yeah.
actually have a constituent case regarding just that, but it becomes germane here. Look, if you're caught, there are bills this session we're talking about admissibility of evidence regarding wiretapping,
Right.
and I just want to be clear how that applies. Okay, thank you.
I want to speak on that. I want to speak on that real quick.
Go ahead.
The question that you asked is exactly underlines the problem here, and that is that this is a wiretapping law that was created decades ago, before things like Ring doorbell technology were even conceived of, or in my case, live streaming technology with cell phones. And so, that's sort of the answer is, does this wiretapping felony penalty cover things like a Ring doorbell recording without people's consent? Because these technologies are so new, no precedent has been set yet. And so when you have such a steep potential penalty of a felony, when you have people in my position where you have the ability to set precedent, when it's such a severe penalty, most people are going to be sort of scared away from even testing the case and instead forced to just opt into taking a plea deal like I did in my case. And so I think if the penalty was a little bit more in line with what their quote unquote crime was, we would have people being willing to test the limits of this wiretapping law.
Okay, any further questions for this panel? Delegate Tomlinson, I think. Delegate Tomlinson?
Thank you, Chair. This question is for Mr. Burdett. I'm sorry if I'm out of the loop here. What exactly did you do? I swear I don't know what the story is.
Yeah, so I attended a marijuana legalization protest that was not organized by me. I was just somebody attending as a protester. At Congressman Andy Harris's office, at his constituent office, public taxpayer-funded space in his district office in Salisbury, where I was a student. And I live streamed the protest on my cell phone on Facebook Live, as many people tend to do at live streams. And I didn't even know about this two-party consent law at the time, in fact. And, little did I know that we do have the two-party consent law. And so in the next couple of days, Andy Harris's office pressed 2 felony charges against me for live streaming the protest without the consent of the staffers, for which I was facing 10 years in jail for, and 2 felony charges. And, potentially I could have fought the case in court, challenged it on grounds of constitutionality, but because I was so young, the penalties I was facing was 10 years in jail and 2 felony charges. My lawyer told me it's not worth the risk, just take the plea deal. And so I had to take a plea deal where I was on probation for 3 years and actually just got off. And that whole experience led me to go to law school, which is where I'm testifying from today, University of Baltimore. So that was what happened there.
So you received a probation for judgment, is that what you said?
Yeah, 3-year probation before judgment deal, or I could have tried to fight the case, but the potential penalties I was facing was 10 years in jail and 2 felony charges. Simply for live streaming a protest.
And now he can't have.
In which he was present or not present, Congressman Harris?
The intention was that he was going to be present. He ended up not being present, but nonetheless, it was still at his office at, public taxpayer-funded space.
Gotcha. Okay. Thank you.
Yep.
Delegate Conaway?
Thank you, Mr. Chairman. Thank you, Mr. Burdette, for coming in to testify. First of all, in this committee, ignorance is not an excuse for the law. You aware of that?
Yes, I am aware of that, and that is why I did not present that as a defense, during my case.
Well, you were stating that you didn't know what the possible outcomes of your action could have been. But I want to know this. If a person, let's say, owns a gym and they're doing that secret recording of people in the locker rooms and they post that on the internet, would that be a felony under this law, or would that be a misdemeanor?
It's all about, did they have the reasonable expectation of privacy? But the point that I want to
when you go into a gym and you're changing your clothes and you might be naked or halfway naked, do you expect a certain level of privacy and not to be recorded, and not for your recording to be placed on the internet?
Absolutely, and you could still have a law that makes recording people, changing without their consent.
Thank you. We have one right here. Thank you.
Well, there are other laws
Yeah, more
that would
specific.
prohibit that, as you know.
Thank you, Mr. Chair. Just real quick, so there's a difference, though, between the question of admissibility and the question of liability for a felony, right? So one of the things that Delegate Grammer was asking you about was the question of whether these recordings, which, by the way, we're only talking about audio, the visual recordings, there wouldn't have been any issue. In fact, Mr. Burdette would have actually, I'm asking this to the OPD, Mr. Burdette would have, there wouldn't have been any crime if he was just video recording without any audio. Is that correct?
I do not know off the top of my head, but
Okay. So it's true that
That
it's
is my understanding.
Two-party, wouldn't it be true that it's a two-party consent for audio recording, right?
yes.
Okay. So the question is whether the police are going, whether a judge would find admissibility of audio recording, the admissibility of it either appropriate or inappropriate based on whether there was consent, versus whether the police choose to actually allow the charge to go forward and the prosecutor take the charge as to whether somebody was audio recording. That seems to be, Mr. Burdette, is that a distinction that you would agree with?
Sorry, could you repeat that one more time?
So
Yes.
the question is not necessarily whether it's admissible in court, but whether a state's attorney wants to take the case that Mr. Harris wanted to bring. And in this case, the state's attorney apparently was willing to take the case. Is that correct?
No, the state's attorney was not willing to take the case. Actually, it was a rather odd prosecutorial pattern. It was actually the state prosecutor that went after me, but I believe the state's attorney recognized sort of how optically poor prosecuting that case would be, and so it was not the state's attorney, no.
And one last question for you, Mr. Burdette, is maybe while you're in law school, you can look to see, because this is a question that's come up to me quite a bit, is if and when you have an opportunity to have this expunged, which I'm assuming you should be able to, I don't know whether it's been 3 years or not yet, but maybe once you have it expunged, the question is, are you permitted to then, when somebody says, have you ever been charged with a crime, the answer to that question is still up in the air, and I'd be interested to see what your studies brings you to believe, whether you're allowed to say, no, I was never charged with a felony, or whether you have to admit that if asked.
Yeah, I actually have 3 years has passed, so I have luckily been able to expunge my record. But the answer about the hiring question, a lot of employers seem to be adjusting their methods. They used to ask, have you been convicted of a felony? In Maryland, because I accepted the PBJ, I can truthfully say I've never been convicted of a felony, but now many employers are changing the phrasing to say, have you ever been charged with a felony? And technically, yes, I have been charged with a felony. So if I'm being truthful, I have to answer yes to that question. That has made it harder to get hired at places.
Seeing no further questions, we thank you all very much. And that concludes the testimony for House Bill 362. Now we have two pieces of legislation from Delegate Bartlett, our last two pieces. It's only 1:30. Let's see what happens next. House Bill 385, Delegate Bartlett, will be joined at the table by her first panel, which includes Ms. Hilliard, Margaret Berry, Kimberly Watts is virtual, and Sarah McKinley. Do we have Ms. Watts?
Yes.
Come on up.
I'm virtual. I'm right here.
All right, that's great. We will hear from you here in a moment. What we'll do is we'll hear from Delegate Bartlett, Ms. Berry, Ms. Hilliard, Ms. McKinley. Sarah McKinley?
Sarah's not testifying.
Sarah's not testifying. Okay. All right, so we'll take her off. We'll hear from the people at the table first, and then we'll hear from Ms. Watts, and then we'll take questions, and then there's a second panel. So with that, Delegate Bartlett, if you'd like to begin, please.
Thank you, Mr. Chair. I'm not quite ready. I'm almost ready. I brought all my material because I know with it being Valentine's Day, you all do not mind being here for a very, very long time. So with that said, Mr. Chair, Mr. Vice Chair, and members of the committee, I'm Delegate Sandy Bartlett, representing District 32, Anne Arundel County, and I'm asking for a favorable report on House Bill 385, Correctional Services Restrictive Housing. We have a cross-file in the Senate with Senators Carter and Washington. House Bill 385 will require all personnel officers and hearing officers involved in the supervision and care of individuals placed in restrictive housing to complete training, 40 hours of training, in the areas of trauma-informed care, the physical and psychological effects of restrictive housing, procedures and due process rights of incarcerated individuals, and restorative justice remedies. Both personnel and hearing officers shall receive 8 hours of additional training annually. House Bill 385 also defines the meaning of restrictive housing, which is a form of physical separation that has not been requested by the inmate, and any form of housing that separates the incarcerated individual from the general prison population. The bill sets forth requirements for how long an incarcerated person can be placed in restrictive housing, and House Bill 385 also places the requirement on a managing official of a correctional facility to ensure that each person placed in restrictive housing is provided with the reasoning of their placement within 24 hours and in a language that they can understand. And if you listen to my testimony, you'll see that nothing that I just said was unreasonable. And this is the way I would like for it. This is my proposal. If we're talking reform these days, that's a word you hear a lot. We're talking rehabilitation. We're talking reduction. And you combine all that with also what is a well-known document called the U.S. Constitution that consists of the 8th Amendment. We want to look at ways that we can truly rehabilitate, reform, and reduce folks going back and forth into the jail system. So we have an ombudsman bill that would be effective if passed July 1st, 2023. This bill could work in conjunction with that ombudsman bill. Pass that, it'd be effective July 1st. Beginning October 1st, all personnel in the correctional facility would receive the training that I mentioned earlier, and then beginning January 1, 2024, the vulnerable individual part kicks in. Very quickly, I will say we offer an amendment for local so that they would not have to partake in this process at this particular time. Thank you.
Thank you, Chair, Vice Chair, members of the committee. I will note that the UN has established a 15-day period of solitary confinement is torture. The impact that solitary confinement has on incarcerated people is profound and immeasurable. We understand that the opponents of this bill find this to be very intrusive and very burdensome. And it is, and it has to be, because when we incarcerate individuals and hold them in restrictive housing, we must be doing so when it is only absolutely necessary and in the least traumatic way possible. We understand and urge consideration that the better conditions for people who are incarcerated will also create better working conditions for the people who are working in the DPSCS facilities. For these reasons, and the reasons you will hear from Ms. Watts and Ms. Pizzo, we urge a favorable report on this bill. And we also, as the delegate pointed out, urge consideration and a favorable report on the Correctional Ombudsman bill that will aid in giving bills like this and much needed reform in the DOC and DPSCS facilities the oversight that they need. Thank you.
Good afternoon, everyone. My name is Margaret Martin Barry. I'm an emeritus professor of law and former director of the Reentry Clinic at American University's Washington College of Law. The Reentry Clinic represents juvenile offenders serving life sentences in Maryland prisons. Nelson Mandela described solitary as the most forbidding aspect of his prison life. This is a man who experienced brutal beatings, other humiliations and deprivations, but solitary was the thing he identified. And from research on solitary in this country, we have evidence of the mental and physical deterioration that it causes. Visual and auditory hallucinations occur, hypersensitivity to noise and touch, insomnia and paranoia, uncontrollable feelings of rage and fear, distortions of time and perception, and increased risk of suicide and PTSD. I've worked with people who describe these symptoms and their ongoing impact. The consequences affect their families and the communities that they struggle to function in upon return. We expansively use solitary. We use it for minor infractions, for suspected affiliations, for so-called protection, as well as for people who do serious harm in prison. And it is destructive on all counts. This bill sets much needed parameters for the use of solitary and importantly encourages the department to develop alternatives to its use. So on behalf of WDC and Major, who I'm here to testify on behalf of, I urge the committee to favorably and expeditiously report the Maryland Mandela Act. Thank you.
Ms. Watts, please, then we'll take questions.
Thank you. I'm Kimber Watts, an attorney with the Office of the Public Defender. Restricted housing is more commonly called solitary confinement, and so that's how I'll refer to it. From talking to my clients, I can tell you that people are locked into cells smaller than the size of a parking space for 23 hours a day alone. The appeal of solitary confinement in a prison setting is its simplicity. It's easy to effectuate. However, as you just heard, it's not been found to either reduce behavioral infractions or recidivism and has been found to cause great harm. By way of some information on how often it is used, the Department of Public Safety and Corrections files an annual report on their use of restrictive housing. In fiscal year 2021, DOC housed over 18,000 people. 3,000 of them, 18% of them, were placed in restrictive housing at some point in time, and more than half of those who were in solitary confinement were so for administrative reasons rather than disciplinary reasons. It's also most often used on African American people. 3/4 of the men and half of the women placed in solitary confinement were African American. Mental health professionals have long known that the solitary confinement causes significant harm. The American Psychological Association has come out strongly against the use of solitary confinement, noting those harms. Courts have also acknowledged that by causing the harms caused by solitary confinement for inmates already suffering with mental illness can amount to cruel and unusual punishment. With that in mind, it's important to note that the Division of Corrections says it housed 338 people with serious mental illness, which incidentally is 500 fewer than in 2020 and 2,000 fewer than in 2019. While in solitary confinement, 6 people made suicidal gestures, including one person who indeed died from suicide. Another 2 people died from other causes while they were in solitary confinement. For all of these reasons, we ask that you issue a favorable report on the Mandela Act. I thank you for your time today.
We'll go to questions now. We'll start with Delegate Williams, then Delegate Erican.
Thank you, and thank you all for your testimony today. I guess my question is more, either for Ms. Hilliard or Ms. Watts. I'm assuming you've had clients who have been in solitary confinement, and I guess my question is twofold. You talked, one, about kind of the trauma that it causes. I was wondering, one, if you could kind of speak to what you've experienced with your clients and visiting them who are in solitary confinement, and 2, have you experienced any challenges with accessing those clients who are in solitary confinement?
I can speak to that. Okay. I've definitely represented people who've been in solitary confinement. The bulk of my work as a public defender has been in representing kids charged with adult offenses, and so many of them, all of them in fact, at one point were held in protective custody, which was solitary confinement. I had more than one client who was suicidal, and we're talking people under the age of 18. It's very challenging to work with them. I mean, they decompensate mentally, they become incompetent to stand trial. When it comes to and that's in the local detention centers. When it comes to the Division of Corrections, I can tell you I have a client who's at one of the DOC facilities now who spent about 2 months in solitary confinement as administrative segregation. He's a young adult who had 0 infractions and still has 0 infractions. He was in solitary confinement while they were investigating someone else. It was very difficult to be able to reach him during that time. He was allowed limited phone calls, and so it was hard to check on his well-being. And although he has remained infraction-free, I'm very proud of him for that, it did have some deleterious effects on his stability.
Gotcha. And you've talked about them having, certain mental health crises. When those occur, are there any resources there at the prison for them to help them deal with their mental health challenges, or if they are experiencing a mental health crisis, any resources to help them get through that crisis?
Theoretically, the problem becomes whether they are limited in receiving those services while they're on solitary confinement, and that, particularly as it relates to local detention centers, varies from place to place. All Division of Corrections facilities, as I understand it, are supposed to have infirmaries, but they are not all equally equipped to handle people undergoing serious mental health crises.
All right, thank you.
My pleasure, thank you.
Thank you, Mr. Chair. My question is for the sponsor. So let's say we have a situation where one inmate is physically or sexually abusing other inmates. Under this new bill, what would be the recourse? How would we protect the victims from the perpetrators if we're extremely limited in how we're able to use restrictive housing going forward?
The limitations around restrictive housing are not that it doesn't exist.
Right.
So you could still separate the individuals. The one who needs protective custody could go into restrictive housing, as well as the one who was the perpetrator. So they could still be separated.
For how long, though?
Well, it would be based on the confinement of the law as we have it, and that would be that they could be placed there for, I think it's 22 hours. I can't find it right now, but it was 22 hours, I believe, with 2 hours of time to get out to shower and recreational.
Okay, I don't know if you've read yet DPSCS's.
Oh, yeah.
There's a lot. It's very, pardon me, it's very dense. I'm losing my voice. I'm sure my chair is going to be thrilled when that finally gets me real good. But they said that there was some discrepancies with how long. So it says here it switches from 15 days to 60 days in a 365 period, but it only allows 3 consecutive days. I don't know if you want to speak to why there seems to be some discrepancies as to the length of time that's permitted.
Well, I can, unless any of my panel wants to talk about it. If you do, if you don't, it's fine.
I can briefly note that the 15 days is a consecutive limitation, so beyond 15 consecutive days, and then the 60 days is a limitation during a 365-day period, so that the 15 days can be utilized more than once if there is a necessity for using restrictive housing more than once.
And if there's a second infraction.
So what's the 3 then?
I'm sorry?
What's the 3 consecutive days that's mentioned? What does that apply to?
I will have to find it. Give me one moment. It is a long bill. I apologize. You have to have an and this is on page 6.E. An incarcerated individual shall be provided the opportunity to contest the restrictive housing placement within the 72 hours, within 3 days.
Okay, so they just have an opportunity to contest. It's not a restriction. So if somebody was harming other people, they would still be able to remove for 15 days. After the 15 days, what happens? They have to be released? How long, what's the gap look like?
Well, they could be released unless there's a second infraction.
Okay, so so they'd have to make another threat of violence towards somebody to be put back into restrictive housing again.
Right.
And there are also other measures that can be taken that are not specifically restrictive housing.
Right.
So, they could move them to a heightened security tier or move them to another area and attempt a less restrictive mechanism that will still provide them control over the individual if they are still worried, but there's not a subsequent infraction.
Understood. Okay,
the,
thanks.
The problem is that you're trying not to, some people, have said that solitary confinement make men go mad. That's a quote. I can't give you the root of the quote right now, but the whole point is that folks who have been in solitary confinement, their response is that I have nothing while I'm in there but my own thoughts and the madness of my own thoughts. There's no rehabilitation in the sense of you're not going to any type of anger management or programming to help you deprogram some of your action. None of that exists. Now, mind you, our prisons or our correctional facilities supposed to be all sunshine and roses? No, I agree. They should not be sunshine and roses. There should be some parameters put around it. But the problem is that if we are talking about mental health, as much as we talk about mental health these days, you don't want to do things that are going to increase a person's level of mental health to the point where, then they may reoffend and go back into restrictive housing. We all know that you keep doing the same thing, expecting a different result. That in itself is a form of insanity.
Yeah, I think the concern is really just making sure that inmates and officers are kept safe from people whose violence is unmitigated. Yep. Thank you.
Thank you. Delegate Bartlett, just to make sure I understand, could you reiterate what you said about local facilities?
Sure. So I was offering an amendment. I'm going to offer an amendment to the bill. As you see, we have a great deal of unfavorables from the local counties. And with this being such a comprehensive bill, I would offer that we present it with the state facilities first and then give us some time to work with the local counties so that we would remove the local requirement or local mandate from the bill.
And just, sorry, as a follow-up, that would include Baltimore City?
Yes.
Okay, thank you very much.
Thank you.
To follow up on that question, it would include Baltimore City despite the fact that they were operated by the Department of Public Safety and Correctional Services.
Well, you know what? I will tell you this. This development literally came right before our hearing. So we can negotiate that, and it probably wouldn't, to that regard, no, it probably wouldn't be able to include Baltimore City. But some of the counties, or not some of, but all of the counties, we did extend the offer to not include the counties. Baltimore City was not part of that discussion, and so we would need to see if there's any room that we could do with respect to Baltimore City. Although, as I look, did Baltimore City come out unfavorable? And I don't believe they did.
Are there further questions for the panel?
Oh, no unfavorable testimony from Baltimore City.
All right, thank you very much. We'll go to the next panel. Did hear from this once. Yes, we did. All right. Mary Pizzo, Emma Holcomb, Kim Haven, Natasha White, Lauren Pruitt. He's on my right, your left, first on the left, and then we'll go across. Go right ahead.
Good morning. Thank you all for hearing my testimony. My name is Natasha White. I'm a formerly incarcerated survivor of solitary confinement and the Director of Community Engagement for Interfaith Action for Human Rights. I want to tell you all, for a person that has experienced this form of torture and has witnessed the effects of it, that this practice is the most inhumane practice that can be done to a people that you say you want to rehabilitate. Solitary confinement diminishes not only a person's dignity, a person's moral standards, the way a person thinks. It causes long-term, life-term forms of self-isolating. If I couldn't begin to tell you how many effects negatively it has had on my life. I have witnessed women who have committed suicide. I have witnessed women mutilate themselves just to get out of a cell. Not only was I in solitary confinement, so was my husband. He was in solitary confinement for 12 years. When he came home, he did not know how to deal with a wife and everyday life, to the extreme where he almost killed me in a regular altercation. There's a very big misconception that people go to solitary confinement for the most worst things. However, how many of those people are recharged with a new crime? Not many. I went to solitary confinement for approximately 4 years just because of who I was married to. And he was not in a woman's facility. There is a better way to go about rehabilitating and holding people accountable. Solitary confinement does not deal with the underlying issues of a person's behavior, and it is not a fix. These people come home and their families are now traumatized as well. You traumatize one person, you've traumatized the community. Thank you.
Good afternoon. My name is Kimberly Haven, and I'm here on behalf as the Legislative Liaison for Interfaith Action for Human Rights. You have my written testimony, which is sort of cut and dried, and you have the bill. What I want to talk about is a little bit more personal and from the heart. I have seen a woman cut her tongue because she thought she was a snake. We've all heard about Emily Butler hanging herself, which led to Disability Rights Maryland filing a lawsuit against the state. Solitary confinement does not work. It just does not. I know that you have opposition from the Maryland Correctional Administrators Association, who said, and I quote, "Never has there been a more intrusive bill introduced." Well, to quote my favorite singer, Lizzo, it's about damn time. We need to reform solitary confinement restrictive housing. It does not work. Research shows it does not make our institutions safer. It does not make our staff safer. It does not make our incarcerated population safer. All of them are damaged. The United Nations and other countries have come out and said anything more than 15 days is torture. In their statement, they also said, and I quote, per advocates or according to advocates or despite what they say, we do not, in big, bold capital letters, put people in dungeons and leave them there to deteriorate. Well, clearly they've never been to Patuxent. Clearly they've never been to Sea Wing at MCIW because it is a dungeon. It is cold, it is damp, it is loud, it is noisy, it is smelly. The only thing it doesn't have is a moat and a dragon. According to the fiscal note, DPSCS put 12,000 people in restricted housing in fiscal year 2022. Our prison population was 16,000. So 75% of our people went into restrictive housing. They weaponized restrictive housing. The threat alone is a weapon. I urge a favorable report on the Marilyn Mandela Act, HB 385.
Thank you to the chair, the vice chair, and the members of the committee. My name is Emma Holcomb. I'm here from Disability Rights Maryland. Disability Rights Maryland is authorized under the Protection and Advocacy for Individuals with Mental Illnesses Act to protect and advocate for the rights of individuals with mental illness in Maryland. DRM has worked to document serious issues in state correctional facilities and advocate for improved conditions, particularly in restrictive housing units. Our testimony is informed by what we have learned through this work and from those who are directly impacted. As others have previously noted today, studies have shown that confining an individual to a cell for 22 hours or more per day can cause depression, trauma, paranoia, anxiety, suicidal ideation, and exacerbate existing mental illnesses. DRM's investigations have revealed that individuals with serious mental illness are placed in restrictive housing at higher rates and for much longer than individuals without serious mental illness in Maryland. Very little, if any, mental health services are actually provided to individuals in restrictive housing units to mitigate its harmful effects. Healthcare records we have reviewed indicate that some individuals may not receive any structured out-of-cell services or programming for months at a time. Mental health treatment in restrictive housing is typically limited to psychiatric medication or worksheets. The quality of this mental health care is grossly inadequate. This bill would prevent the placement of individuals with serious mental illness in restrictive housing. Many organizations, including the National Commission on Correctional Health Care, have recommended that restricting housing not be used for individuals with serious mental illness. In cases where restrictive housing is used for anyone, adequate out-of-cell time should be consistently provided to mitigate its harmful effects. This bill would finally bring Maryland in line with these recommendations. I appreciate having the opportunity to speak with you today, and we urge the committee to provide a favorable recommendation for this bill. Thank you.
Good afternoon. My name is Lauren Pruitt, and I'm the Legal Director for Free State Justice, Maryland's civil rights advocacy organization for LGBTQIA+ Marylanders. I'm here today supporting House Bill 385, a history of abuse and profiling towards LGBTQIA+ people by law enforcement, along with high poverty rates, homelessness, and discrimination in education and employment, has contributed to increased contacts with the criminal justice system, leading to higher levels of incarceration. When finding themselves incarcerated, jails and prisons are traumatizing, dangerous places. Being LGBTQIA+ means humiliation and abuse, sometimes both physical and sexual, by other prisoners, also correctional officers and staff. Many LGBTQIA+ people are placed in solitary confinement just because of who they are, many times against their will. This protective custody remains in widespread use in many institutions, even when evidence shows that considerable health risk to prisoners and likelihood it undermines correctional security. The organization Black and Pink released a groundbreaking report in 2015 examining the experiences of incarcerated LGBTQ people. 85% of respondents reported they had spent some time in solitary confinement. Of those, almost 50% had spent 2 years or more in isolation. Reporting found that transgender women and cisgender gay men were put into solitary confinement against their will at the highest rates. Correction systems have increasingly relied on solitary confinement as a prison management system and tool to the detriment of the isolated individuals. But solitary confinement jeopardizes our public safety, is fundamentally inhumane, and wastes taxpayer dollars. We must insist on humane and more cost-effective methods of punishment and prison management.
The Mandela Act's additional training and monthly reporting requirements, which include recording gender demographic information, coupled with the overall time limitations and out-of-cell movements while unrestricted housing, are the types of protections needed for incarcerated individuals, especially members of the LGBTQIA+ community. And for these reasons, Free State Justice urges a favorable report on House Bill 385.
Ms. Pizza, please.
Thank you. Good afternoon. My name is Mary Pizzo. I'm with the Public Defender's Office Forensic Mental Health Division as well. I'm not going to reiterate all the concerns that there are about solitary confinement. You heard that, and you heard that from somebody who actually had to experience that horror. But I will point out some other problems with it. There are people who are in solitary, and we are calling it solitary confinement. They're relieved of almost all of their privilege, phone calls, training, access to any activities whatsoever, work programs, even limitations on being able to speak with their attorney, because we are limited by the amount of time that they're allowed to be released from their facilities and how that can be managed in the system. This law does not make it any as onerous as the department would have you believe. In fact, this law includes things that the department is already doing. For example, in its annual report, the Department of Public Safety indicates that it's against policy to put pregnant women in solitary or in restricted housing, as they call it. So if they can do it for one class of vulnerable individuals, certainly they can consider it for others. And certainly training, there is nothing wrong with getting the training that is suggested in this bill, which includes trauma-informed information about trauma-informed behaviors and trauma-informed concerns, because virtually everyone in the prison system is affected in that regard. I would say that in 2016, this legislature mandated that Department of Public Service do a report on restricted housing. In that report is virtually the only time there's any mention of the word in the statute of restricted housing. There are remarkably no comprehensive statutory or regulatory guidelines for the administration of restricted housing within the Department of Corrections. And as I said, in fact, the definition of restricted housing itself appears only in the portion. So we would ask for a very favorable recommendation by this.
Are there questions for this panel, please? Delegate Williams.
Thank you, Mr. Chair. Ms. Haven, you had mentioned the letter from the Maryland Correctional Administrators. And so one of the things that they mentioned in their correspondence is that there are legitimate uses at times for restrictive housing, just to ensure kind of the orderly operation of the facilities, the safety of individuals. As someone who's been in the system, I mean, what is your take on that?
Well, research would bear to differ. Again, we have states that have abolished the use of restrictive housing. That's not what this bill would do. When they said in their statement that there is a legitimate use, there's not. Research doesn't bear that out. When we talk about treating people who are incarcerated, prison is the sanction. We must put dignity and humanity back in how we treat people, because 95% of the people that we incarcerate come home. And what we do to them is what they bring back to our communities. The young lady that I mentioned that cut her tongue because she thought she was a snake, the person who has spent so many years in solitary confinement that when he went home, he was released to his mother's house and he'd never left his room. He went out and got dinner and came right back. He didn't know how to use forks. He didn't know how to socialize. He didn't know how to adjust back. So there is no legitimate use. It should be used only after the least restrictive measures have been taken. And that's what this bill would do. Colorado has instituted something where they put somebody in a blue room because they weaponize the threat. All you have to do is crack slick to a CO. and they threaten you with going over, and that's what the threat is. You lose your programming, everything is interrupted. They take your stuff, it's broken, they trash it, the whole 9 yards. And then they find you not guilty, and then you got to go back and start all over again from scratch. There is no legitimate use. You could be having a bad day. I'm going to pick on Delegate Grammer, just so I want you to make sure that we're... Delegate Grammer, let's say he's a correctional officer, and he's having a bad day because he tripped up coming out of the door. I'm having a bad day because I just left the chaplain's office and found out my mother died. And he says something to me about walking on the grass, and I crack slick. And what's he going to do? That's it, Haven, you're going over. Going over, they've weaponized the very concept, when instead, let's do some de-escalation. What's going on? Do we have a mental health issue that needs to be addressed? Do we need a social worker? Do we need a chaplain? What's happening? And we don't do that. Think of it like a timeout. Everybody needs a timeout. You're having a bad day, and you say to your kids, go to your room, I don't want to talk to you right now. And you take a breather. Let's take a breather. And so when the Maryland Association of Correctional Administrators said there's never been a more intrusive bill, like I said, Lizzo and I agree, it's about damn time. Let's do this. Let's become a leader in how we reform the use of restrictive housing. Eliminating the counties is a huge step. Let's work on the state. The counties have a whole lot of issues that we've been talking to them about, and we're going to work with them on this stuff. But let's take care of the people that are in our care, custody, and control, and stop thinking of it as care, custody, and control, and start thinking of it as care, custody, and management. 12,000 people cycled in out of restrictive housing last year. 75% of our prison population. That can't be allowed. That demonstrates Maryland's abuse, overuse, and misuse of restrictive housing. Thank you, Delegate Williams, for that question.
Further questions for the panel? Seeing none, we thank you all very much for testifying. I'm sorry, I missed one. Delegate Taylor.
Yes, just a quick question to the young lady who was incarcerated. Thank you for your courage to be here today. 2 questions for you. What did you mean by you were put in a hole because of your husband, and he wasn't even in the same facility as you? And then my second question is, were you incarcerated in a state facility or a local facility?
So to answer thank you also for your thanks. For the first question, when I got to the state facility, so when I was in the county jail, I was marked as SRG for my husband's alleged gang status. And then it followed me to the state prison. So they already had me marked down as a gang member, which I've never been a gang member. The warden said that I would never corrupt her jail and that I would stay in lock until I was transferred. I did a total of 15 years. I did 4 years in the first facility. So until I was drafted, when my numbers went down, which took forever because I wasn't doing any programming, I stayed in solitary. Your second question was again?
Local or state?
State.
Thank you.
You're welcome.
Further questions? Seeing none, we thank you all very much, and that concludes the panels in favor of the legislation. Now we're going to hear from people opposed to the legislation. Brandon Foster, Dennis Strine, Mary Ann Thompson, Jerome Smith, Thomas Reese. We'll hear from those 5. You're going to have to add a chair up there, and we'll have to do-si-do some people out, in and out after you've finished speaking. We'll hear from those 5 first, and then we'll move through the rest of the unfavorables. So let's hear, sir, go ahead.
Good afternoon, Mr. Chair.
Don't press the button. It'll get there. Please, there you go. Go ahead.
Good afternoon, Mr. Chair, Vice Chair, members of the committee. I am Brandon Foster, the Director of the Charles County Detention Center. I am speaking on behalf of Charles County Sheriff's Office, the Maryland Correctional Administrators Association, and I also represent the exceptional and often unrecognized correctional officers across the state. And I also I represent the incarcerated persons in Maryland who simply desire to do their time safely and to be better people when they're released. Our first mission and role is to provide for the safekeeping and welfare of those placed in our custody. Our secondary mission is to provide for meaningful programs and services for the rehabilitation of inmates and to be a positive influence in their lives while they're under our care. We would never be able to accomplish this without the use of restrictive housing. Contrary to the testimony of many advocates for the abolishment of restrictive housing in jails and prisons, modern-day correctional managers do not place inmates in dark dungeons and leave them there to suffer in mental and physical decline. These decisions are very carefully made. The mental and physical well-being of inmates are always priority, and the least restrictive means are always considered. The use of restrictive housing in correctional settings is a critical necessity, and the decisions concerning its use must be under the full authority and discretion of experienced managing officials. Limiting the restricting its use by law would place managing officials in a terrible situation whereby they would be limited to taking necessary action to protect the vulnerable and maintain good order and discipline. These conditions would set the stage for managers to essentially ignore risk and to be deliberately indifferent toward the safety of all persons in the correctional facility. The language of this bill demonstrates a complete misunderstanding of jail and prison operations. It is extremely dangerous and would create potential risk of life and limb to confined persons and those responsible for their care, their custody and care. In society, when a wolf, a violent criminal, is preying on the sheep, the innocent citizen, it becomes necessary to remove the wolf from society and place him somewhere, jail or prison, to protect the sheep. Jails and prisons are microcosms of our society. It is no different in the jail or prison community. It is our obligation to protect the sheep from the wolf. We accomplish this through the use of restrictive housing. Whether we are talking enemies, co-defendants, witnesses, mentally ill persons, vulnerable persons such as elderly or youth, or those who are extremely violent, the decision to place an inmate in restrictive housing must reside with the managing officials of jails and prisons in Maryland. In my 28 years in public safety, I have never seen proposed legislation as intrusive in jail and prison management as HB 385. The contents of this bill are antithetical to our mission of safety, protection, and rehabilitation. What seems to be missing from this conversation is the identification of any specific problem with the use of restrictive housing in Maryland. I ask this committee what problem has been identified that brings cause for the introduction of this legislation. Is it being introduced simply because it's trendy or fashionable somewhere else? And to that point,
Sir, we're going to give you 15 more seconds. Our clock is no longer working. I'm going to start keeping the time from here. So 15
in
more
California's 22 legislative session, a similar bill was introduced, and in 2023 it was introduced again, called the California Mandela Act. California's Governor Newsom vetoed it in writing, quote, saying the bill establishes standards that are overly broad and exclusions that could risk the safety of both staff and incarcerated population within these facilities. It seems Governor Newsom in California probably understands the risk just as we do. Thank you. We ask for an unfavorable report on HB 385.
All right, we're going to try and put the clock back up on the screen for 2 minutes. The bell doesn't appear to be working at the end of it, but are you ready? You ready for that? All right. Please, I'll have a backup timer. Go ahead.
Good afternoon. I am Mary Ann Thompson, Warden of the St. Mary's County Detention and Rehabilitation Center and President of the Maryland Correctional Administrators Association. The safety and security of those entrusted to our care is paramount. The old philosophy of lock 'em up and throw away the key is no more. Correctional philosophies have evolved to a health equity mission. Our facilities must be safe and secure, providing therapeutic environments for the physical and psychological well-being of both the incarcerated individuals and those corrections professionals who quite frankly walk the toughest beat in America. Correctional officer vacancies abound throughout the state of Maryland. Without restrictive housing, jails lose the ability to keep those in crisis safe, as well as other incarcerated individuals living in the same housing unit. No two jails are alike in Maryland, and there is a misnomer that the jail medical and mental health programs provide the same level of service as a hospital. Jails have become de facto mental health institutions. An individual cannot be forced medicated as jails do not have the resources of the state mental hospitals, nor are jails authorized by law. The Maryland Department of Health is unfunded for hospital bed space, and there are not enough mental health resources in the community. The law clearly states the individual is to be transferred within 10 days of being found incompetent, and this is not happening. The offender reentry process begins at incarceration to ensure the best possible safety net at release. Local jails are the places to effect positive change in an individual's life, but there must be a safe environment for the incarcerated and the corrections professionals who choose to work inside the walls. The Maryland Correctional Administrators Association respectfully requests House Bill 385 be opposed by the committee. It is important to remember if you have visited one jail, you have only visited one jail. I personally extend an invitation to visit any of the local detention centers in Maryland. Lastly, if you have any questions of my MCAA colleagues and myself, we are here and welcome questions from the committee.
Good afternoon, Chair, and thank you for this opportunity to testify today. I'm Colonel Dennis Drine from the Carroll County Sheriff's Office and the Warden of the Detention Center. I'm here today in opposition of House Bill 385 on restrictive housing. Our correctional officers work hard, often for long hours and under difficult conditions. We must protect them from unreasonable danger and be able to effectively handle and classify inmates that conduct predatory and aggressive infractions within our institutions. Administrative and disciplinary segregation is the key to ending immediate threats to staff and other inmates and eliminates the potential for further dangerous interactions among others. One of the reasons that you do not consistently hear traumatic and grisly stories from local jails is primarily due to the ability of us wardens to exercise our due diligence in segregating problems to maintain control. If the deterrent value of disciplinary confinement is removed, as this legislation would do, inmates would have little incentive to follow the rules. People will get hurt, or worse, to include other inmates. Without a system to prevent order, the inmates will be forced to take matters into their own hands and to protect themselves. Corrections have been asked to support and accomplish many legislative items, but I cannot support legislation that I and other wardens see as posing an unacceptable risk to the safety and security of inmates, staff, and the public. Allow me to finish by asking each one of you to recall the definition of vicarious liability. If this bill is passed and signed into law, it not only forces me to make irrational decisions, but to take unnecessary risks that I know are detrimental to the health and safety of every officer, employee, visitor, and inmate, and completely opens myself, the staff, the county, and the state for future litigation. Please vote against this intrusive measure. It's not only bad, it eliminates us as professionals and our decades of experience to run effective and safe institutions. Thank you.
Good afternoon, Good afternoon, Mr. Chairman, members of the committee. I'm Major T.D. Reese, the administrator of the Calvert County Detention Center and past president of the MCAA. I just want to give a simple and basic formula to describe a local jail's prison population or jail population. 90% of all inmates held in the local jail are no issues. They know why they're in jail, they accept the situation, and will patiently await their court date. This population does not want inmates running the facility. They do not want to be threatened, intimidated, and/or assaulted. They do not want to feel the stress and the pressure every day to choose a side for their protection or living conditions. They only want to do their time and not be bothered. Approximately 10% of the local jail population wants to continue to operate their hustle or crimes while incarcerated, using fear, intimidation, and cunning to enact their will over others. They do not like rules and regulations, nor are they prone to abide by them. However, within this 10%, there's 3% that are dangerous to the other inmates as well as the staff. This 3% of the inmate population desires to be in control, to lead the other 7% in bullying, assaulting, stealing, and intimidating the other 90%. One major responsibility of a correctional officer is to ensure this 3% is not successful. When this small segment of the population acts out, no matter the degree, there must be reaction by the staff. The 90% is watching us. Remember, they have to live with these inmates. They know it is our job to ensure a controlled and orderly housing unit. We cannot turn a blind eye to the majority of our population. A sound, orderly, consistent disciplinary system shows support to the 90% that are not a problem. If the 90% believes we do not care about them, that we are leaving them to the mercy of the 10%, then 100% of them become a problem. The facility becomes inefficient and unsafe for everyone. The use of restrictive housing is an essential tool. Can I finish one little bit?
Finish your sentence, that's fine, thank you.
For an essential tool for the shift supervisors to protect and reassure the 90% that we do care about them and we do appreciate their appropriate behavior. So I ask please to support MCAA and oppose House Bill 385.
Thank you very much. Yep, and if you'll go ahead and switch, and we'll move the microphone back to the third position. Thank you very much, and go right ahead for 2
Good afternoon.
minutes.
Thank you, everyone. I'm Colonel Jerome Smith from the Prince George's County Department of Corrections. I'm the Deputy Director of Bureau of Operations. The stigma that segregation is punitive only hinders others from seeing the positive benefits of administration segregation. Positive benefits include the overall improved safety of detainees and the correctional staff in compliance with the department's goals to provide a safe, secure, and humane environment for all. Institutional rules and regulations, they encourage obedience and enforcement of facility rules, help to staff to manage detainee behavior exhibiting frequent and ongoing patterns of anger, irritability, arguing, and defiance towards other detainees and authority figures. They also have protective custody. The protective custody is to provide a safe environment for detainees with pre-existing psychiatric disorders that are actively symptomatic or psychotic state, to provide positive reinforcement to detainees who are concerned for their safety and general population due to a perceived threat or possible assaults. It also temporarily houses the detainees for reports that feeling unsafe and threatened. It provides the staff the opportunity to investigate these incidents safely. We also have court-ordered segregation. Sometimes the lawyers or the judges will professionally ask for the detainee to be put in segregation for their safety. It's not the inmates or the staff that's asking for it. So this is all some of the things that we have to go through to make sure that we be allowed to take care of our detainees and make sure that we keep them safe.
Thank you. We're going to go to questions now. We'll go to Delegate Kaufman, then Delegate Tomlinson.
If it's okay with you, Mr. Chair, there's just a lot of information, so I have a couple questions. Thank you all for your service. Law enforcement and corrections is not easy, and we all owe you a debt of gratitude. But when I always try to find common ground with people. So, to the gentleman from Charles County, who said it was trendy, I forget. Do you agree that psychologists and psychiatrists know a lot about mental health? Yes or no?
They do.
Very good. So we can agree on that. But the issue is then that the people that you've just acknowledged that have that know a lot about mental health have the American Psychological Association and the American Psychiatric Association have significant concerns with solitary confinement and what it does. So I think that that's just worth pointing out. Also, Delegate Bartlett's bill doesn't eliminate the tool for you. It just eliminates it. It just limits it, rather. My next question is, a lot of you at the table posted a rather dystopian picture of what would happen if Delegate Bartlett's bill passed. Lovely images for Valentine's Day, but there are numerous states that have eliminated solitary confinement. And so do you have any data that you could share with us about how that demonstrates your point that, on a regular basis, inmates are having to, defend themselves and all of the other, stomach ache type of scenarios that you gave? Because I don't read about them in the paper every day, and other states have done it.
Well, I would answer, first let me go back to my point about whether it's trendy. That I made the first point that my question is, what in Maryland, prisons and jails, what problem has been identified specifically to Maryland that would bring cause for a bill that would turn jail and prison operations in Maryland completely upside down in the management and as far as keeping people safe? So I would answer that or make that comment first. Secondly, it was some of the advocates that spoke to some states that have eliminated or abolished restrictive housing. I'm not aware of any. They didn't state which states. I'm not aware of any states that have absolutely abolished restrictive housing. If some have, I would be interested as well to see how that's working out for them. But I know of no states that have abolished restrictive housing.
And the last thing I'll say, Mr. Chair, is I point my wonderful colleagues to the testimony of the letter of information from the ARC of Maryland, which is, in full disclosure, my former employee, which indicates that people with my former employer, rather, which indicates that people with disabilities have been disproportionately held in solitary confinement. You know, we're not going to disagree on this, sir, but I really appreciate your service and this exchange of views. Thanks.
Thank you.
Delegate Tomlinson, then Crutchfield, well, okay, Delegate Tomlinson, then Young, then Crutchfield, then Grammer.
Thank you, Chair. Was it Ms. Thompson?
Yes, sir.
I think you said I invite you to come to any of our facilities. You know, we've heard about, you know, supposedly dungeons and stuff like that. Could any of you guys give us just kind of try to paint an image of what these facilities, you know, what this actually looks like as compared to what we've been hearing prior to you guys coming up?
So we do not have dungeons, and we do not have moats, and we do not have dragons. You know, we have a standard, you know, like each of our facilities, like I said before, each of the facilities in the state of Maryland is set up separately, and I encourage any of you to reach out. If you want to come to St. Mary's, you please come see me, and we'll make arrangements to do that. But it's very much like but our setup will be different than Prince George's County, but I would think they're all the same. We have a day room, and then we have 3 cells that are attached to it. So that allows them to come out for like recreation time and those kinds of things, meal times and such.
If I could clarify some things, because words have meanings. It was correctly stated earlier that restrictive housing is defined in statute in Maryland. Being in a cell behind a cell door for more than 22 hours a day out of a 24-hour period. Most jails, you have to understand, whether we're talking about restrictive housing, umbrella, under that could be disciplinary segregation, administrative segregation, protective custody, a mental health unit, a medical unit. By definition, a lot of these different units within a jail could fall under restrictive housing. Generally speaking, most every warden in this room does everything they can with the limited space they have in their jail to allow inmate out-of-cell time as much as possible, generally speaking. There are some cases, mostly disciplinary segregation, where somebody may be in a true restrictive housing more than 22 hours a day setting. But we are under or subject to the regulations and standards of the state of Maryland. The Maryland Commission on Correctional Standards audits our facilities. There is a complete set of standards that we have to abide by that in regard to mental health and physical health care and amount of space in a cell and how many times somebody gets a shower per week, how much time someone gets out of a cell. These things are all standards that we are audited every 3 years, thoroughly audited. If there are discrepancies, by law, the state can do all sorts of things, including make you cease operations. So our jails are clean, orderly places. Restrictive housing helps us to maintain an orderly facility. I had an inmate who murdered his cellmate in the middle of the night in his cell, carved him up, pentagram in his chest, vile words across his forehead. They come in the morning, they find the cellmate dead. What do I do with that inmate if I'm limited to keeping him in restrictive housing for 15 days in a 365-day period? Do I ignore the risk because I'm handcuffed that I can't, and I put him in general population and he does the same thing there to someone else?
Yeah, a good point. Did anybody else?
I can say in Calvert County, ours is just a regular housing unit. We don't, I mean, it's just a regular housing unit, and we just put the people in there that are on, you know, confinement. That's it. It's same lights, same cell window, outside light, everything. Got a window.
Okay.
Also, we have other regulations that we have to abide to, such as the Prison Rape Elimination Act. Like yesterday, even if somebody just says somebody raped them, we have to follow certain steps. We have to make sure that that inmate is put separate. If we let that inmate out and he gets somebody else, we're liable. So we have to follow certain regulations and protect the inmates. Most of it, like I said, the stigma is saying punishment only. But a lot of it is for the safety of the inmates.
Gotcha. All right. I appreciate it. Thank you.
All right. Delegates Young, then Crutchfield, Grammer, and Williams. Delegate Young.
Thank you, Mr. Chair. A few things, and I'm going to give y'all some context. I'm a son of a correctional officer who retired 20 years down in Baltimore City Detention Center, JI building, all of the stuff downtown. So, and my sisters were both investigators in those jails as well. So I see this kind of from both sides, but I also very much have a specific view on restrictive housing. I want to also note that every year the Department of Public Safety and Correctional Services they submit a report, which is posted online. This year's report seems to be missing though, but 2021 and before is up. And there's a dashboard that also exists. And I'm looking at the dashboard now, so real quick, I just want to ask, if y'all could just repeat which jurisdictions you all are from. I know one is from St. Mary's, one is from Calvert. Could y'all repeat the other?
Prince George's.
Prince George's.
Charles County.
Charles. And Carroll. I appreciate it. Also want to make sure that I let y'all know I'm going to take you up on that offer. I'd like to do a little tour, if you don't mind, during the interim. But the dashboard is really helpful, and I just encourage everybody to look at it because you can really not only see the amount of placements, but also the amount of inmates with those placements. It looks like there were 9,000 people placed in Maryland in restrictive housing last year, and I see that the placements are up to 12,000. My question to y'all, actually, the first question has to do with staffing. We've heard a lot about staffing in the facilities being down. Could you all speak to where your staffing is right now in your facilities?
In Charles County, we're down at 1/3 of our total allotted number.
In St. Mary's, I have 800 officers allotted. I'm down 25 positions.
Just an example, Super Bowl Sunday, I had to keep people on overtime for the third day in a row. That's how short the staffing is in Prince George's County.
We're five correctional.
So my follow-up to that is, how is that impact? I'm seeing like what it seems to be a trend of increasing use of restrictive housing. I would imagine a lack of staffing might have an impact on that. Would you agree?
Could I just to remember, during 2021, we were under COVID protocols, so some of that, the 10-day quarantine goes into that as well. Some of the reporting.
I appreciate that. Recognizing that, is there an impact with regard to staffing and the use of restrictive housing?
Only restriction is basically they have to stay restricted from movement, not in the housing restricted from movement because they may be COVID positive.
I think the better question would be, and back to 21, those numbers, I agree with Mary Ann. Remember, this reporting, they're going to report it the way the law defines it, which is the 22 hours in a 24-hour period. You're locked in more than 22 hours. But that could range across all of those categories that I mentioned. Disciplinary segregation, administrative segregation, PC, during COVID, 10-day quarantine periods. The better question is, what will this bill do to the safety within correctional facilities that will have an ultimate impact on being able to draw people into this line of work in this career? If our jails and prisons become chaotic, dangerous, more dangerous than they are today, I don't know where we're going to find people that want to work in a jail or prison if it's known for being chaotic and dangerous.
I appreciate that. But I do want to just get clarity. Is there an impact with regard to staffing and restrictive housing? Are you seeing as a consequence of less staff that you all are having to rely on restrictive housing more?
I think really the increase in the totals you're looking at in the restrictive housing are main two categories in Calvert County, I'm sure they can all say the thing, is mental health and medical. Detoxing, almost every person that comes in the facility is detoxed right away. I mean, 7 to 10 days, take 4 or 5 days in medical to detox them, and then they go 7 to 10 days on COVID restriction. Up goes my restrictive housing numbers right away. And then the fact that we're in a way problem with mental health, a backlog in mental health that are staying in our facilities. You have 4, 5, 6 people from mental health that are committed to the hospital and are supposed to be transferred to the hospital and staying there for 50 days. They're all restricted housing the whole time they're there. We would love to do something with them. We'd love to get them to the hospital, but I think that's a lot of the increase. Our probably lowest number is disciplinary housing.
Let me just clarify that the dashboard has that 17.4% of the placements in restrictive housing in 2021 were medical, 38.1% were disciplinary. Quarantine, which may be COVID, I'm not sure, was about a quarter.
COVID and detox.
Most likely it is.
Okay.
They were doing a standard induction. All new persons entered into Department of Corrections. They were putting them into a 10-day quarantine period.
I appreciate y'all answering all my questions. One more question for you all. What does it look like with regard to direct release? I'm very concerned about, look, my district, I think a third of residents who return from prison come to Baltimore City. I would imagine I'm just going to be generous and say half of that, maybe a little less. I mean, I'm east and northeast Baltimore, so it could be 1/6 of the prisoners come back to my district. And I'm very concerned about direct release also from solitary confinement as I'm thinking about our violence problem, as I'm thinking about our, when we deal with cognitive behavioral issues, et cetera. So my last question has to do with direct release. How often is that happening and occurring in your facilities? And I understand that obviously everybody doesn't impact Baltimore directly, but I think it impacts everything.
I could answer that from Charles County because we are preparing the report on restrictive housing right now as we speak. And so I looked at the numbers the other day. It was an extremely low number of persons in Charles County that were direct release. In other words, they were in some form of restrictive housing in any of the categories mentioned and were released by the court and went straight from that setting in the jail to the community. It was an extremely low number in Charles County.
Do we have a general sense on the statewide piece?
So like for, like you said, because somebody mentioned about like all the programs these are taking, it's on a case-by-case basis if everybody's programming is taken from them. So some people are still receiving, the services within the jail. Like if their behavior allows, then they still go to programs within the facility. But not every jail is the same. So, and unfortunately, sometimes in local jails, we do not get a heads up that somebody's being released. They go to court and then, they're released out. We're different. We operate differently than the state system. State system, you have a little bit more latitude with that. In local jails, sometimes you just don't know. They go to court and they're just released. But we try to make sure that everybody is set up, offender reentry starts when they come in the door. So when somebody is getting released, we have a plan. So when you come to St. Mary's County, there's a path. So it depends on where you are. So like some people go out on, some people are released right from the commissioner and they go straight out the door. Some people go on like medicated assisted treatment. So when they go on medicated assisted treatment, they have a mental health evaluation. Offender reentry starts at that point. And if you are incarcerated in the jail or you're awaiting trial, then we begin you with offender reentry. So even if you're released out of confinement, then you have a plan. We have been working with you to make sure that you have what you need when you leave the detention center.
I think in a local jail setting, it's very low number of people direct release from disciplinary segregation back to the community. Our largest segment of direct release is probably suicide watch. That they're on a restrictive housing under the definition of restrictive housing, and then released by the commissioner or released by the judge. And then we have protocols we have to take in that situation.
All right, thank you.
And just to add to that, so if somebody's released off a suicide protocol, then the law enforcement is called, they do an EP, and then they make the determination if the person needs to go to the hospital or not.
Understood. Thank you all.
Thank you.
Thank you. Delegate Crutchfield. then Grammer, then Williams.
Thank you, Mr. Chair. This is for the gentleman from Charles County.
Yes, ma'am.
You mentioned earlier that you felt like this bill was a misunderstanding of the jail and prison administration. Can you elaborate a little bit more on what you mean by that?
Yes, I think often, I've testified on this bill in previous years. Often I hear a lot from the advocacy groups, a lot of, I'll call them exaggerations to some degree. This committee, I often run into conversation with certain delegates, even delegates from my own district, from Charles County, and a lot of the times there is a misunderstanding about the internal operations of a jail or a prison in the state of Maryland. There's a lot of assumptions, but that's why this conversation, I think, is so good, that we're sitting at this table and we're being asked questions that are providing real inside information by managing officials of jails and prisons to give you the facts. To give you the facts on what it looks like inside of a jail. I'm just simply stating that often it's misunderstood what actually goes on inside of a jail or a prison in Maryland.
So what does, in this particular framework, what is it that really is causing you to be here today? Because you earlier mentioned that you represent the inmates, you represent a whole gamut of people. And, you know, what makes you feel that you represent all those people? Because I'm sure you have not talked to the inmate population, nor do they know you're here testifying on their behalf. So please tell me what
Actually,
it
ma'am,
is.
I spend personal time with inmate groups all the time. That's what wardens do. Major Reese, he is dedicated to literacy. He's made it a personal, just a personal thing to him in his life and his role as a warden. He personally teaches literacy classes to inmates. I've personally sat down and taught life skill classes to inmates in small groups, large groups. We care, and that is, not to restate everything that's been said, but Major Reese pointed out the 90%. The vast majority of the inmates depend on us to be safe, to feel safe, to be able to go to programs without worries that somebody's going to attack them from behind, to be able to live in a day room where there's relative peace and comfort and you don't have to be looking over your shoulder all the time. I represent them because by taking the small number of people, sometimes by necessity, and putting them in restrictive housing, so the 1 or 2 is not affecting the 98, we have an obligation to protect them and to provide the safe environment for them. So I do represent them. They're not here to speak. Many of them, I'm sure, if given the opportunity, would be here to speak and say, yes, I want that guy in somewhere else in this jail because he's threatening me every day. He beat me up last week. He stole my commissary the other day. So I do represent the 90% that want to safely do their time in the jail. Thank you.
Delegate Grammer, then Williams.
Thank you, Mr. Chair. So, treat us like we're stupid. I've taken a tour of the detention center, but can you articulate for the committee what kind of restrictive housings are there? What purpose do you use them for? How often do you use them? Kind of treat me like I'm a third grader and really just help us have a more clear understanding, please. Anybody or everybody?
Disciplinary is simple. We have a structure of rules, usually different categorized rules from severe to minor. And when the infractions are committed, the person is charged formally. There's a whole process to that. It mimics sort of a court setting. They have a right to witnesses. They have a right to evidence. They have a right to give a statement. And all the things are required by a certain timeline. They have a right to an appeal. That's disciplinary. Sometimes as a result of a sanction, they might be put in disciplinary segregation for a period of time. And even after they get there on good behavior, usually we offer contracts to get out much earlier than initially imposed. Administrative segregation could be a person is mentally ill and they're vulnerable. I could have an elderly person who has, maybe walks with a cane and he is vulnerable to other inmates. I may put him in a unit where he's protected from that. Protective custody is obvious, whether it be request of the inmate, him or herself, or the request of maybe the prosecution or even the defense, that this guy needs to be protected because maybe he's providing witness testimony in a case where he's being threatened. That would be protective custody. Things like quarantine. We did go through a period of time where we were quarantining inmates for 10 days upon entry into the jail. Medical, the infirmary. Somebody has an illness, a physical illness, where they have to be under the watchful care of nurses and medical staff for a period of time. The infirmary doesn't provide, it's not like a day room setting where they have a recreational area for TV and phones and all the rest. They still have access to all those things. But for the most part, they may be behind the cell door for more than 22 hours. So that sort of, I hope that helps. That sort of paints the picture of all the categories and maybe some of the scenarios where someone would be in restrictive housing.
Right. Thank you for that. So we kind of heard it, the terms we use kind of frame the way we look at it. It was, someone had called it solitary confinement, and that paints a picture of a dungeon. Can you help me understand what percentage of the cases, how many of the cases, if you're placing someone for protection of that person, do they go into the dungeon? How often do you use the dungeon, and who goes there and why?
There's no dungeon.
Right. I knew you were going to say that.
But if we take the term solitary confinement, that would indicate that the person is alone.
Right.
But I have no place in the Charles County Detention Center where anyone is alone in the sense that they are distant, in a distance far away from anyone else. Even in the disciplinary segregation unit in Charles County, they're two-man cells. And most of the time, they're celled with someone in that unit. So that there's nowhere in the Charles County Detention Center where someone is, I'm trying to paint the mental picture for everyone, where it's so distant and far away, and they're
it's in the
solitary
basement.
and they're in the
It's
basement,
dark.
and there's
Yeah.
no one ever to talk to, and there's never any interaction with anyone. I probably am speaking for all the wardens here. That doesn't occur.
I think the example that when people tend to think about that we don't want people to be in solitary confinement, what you're saying is even for the disciplinary cases, they're not necessarily away, they're not necessarily alone, it's not necessarily in the dark in a dungeon.
I've got officers rounding every half hour, speaking to them, helping them, bringing them out for showers 3 to 4 times a week, let them walk, up and down the recreational catwalk area, coming out for letter writing time. If you're in there for a certain period of time of good behavior, you get to use the phone. There's all sorts of other parts of that. There's not I don't like the word solitary confinement. We don't use the word solitary confinement. We do not use that terminology.
In Calvert County, it's policy that no single celling. We double cell just to avoid suicide, anything like that. We double cell. Only reason we will not is if the person is so dangerous to somebody else that we have to single cell them. That's the only time we'll single cell anybody.
Okay. The last question I have is regarding numbers. I believe the number that was used, it was 75%. Sounds pretty darn high. Can you kind of speak to that? You've mentioned that you detox a person coming in. Well, if you detox every person, the rate of having someone in restrictive housing is probably 100%. What's the actual, for disciplinary or administrative or whatever, can you kind of walk us through, how often that happens, what % of the population you're actually using that for?
Delegate, what you just said is really the key to the report, to the numbers in a report. We're not going to shade in the numbers and try to shave them down to what we would like it to look like in a report. The definition in the law is 22 hours a day behind a cell door. So that's what it is. So all of these different categories, infirmary, PC, administrative segregation, disciplinary segregation. If it's a situation where it's more than 22, it's being reported. So that's why you're seeing high numbers during the latter 20, into 21, full year 21 period, is because it's being honestly reported by the definition in Maryland law. Right now, what we're doing is we're doing testing upon entry now for COVID, and as long as the person is negative, we move to normal circumstances. So we're always doing things and evolving with you know, what's happening on the ground to make sure that we, overall, general statement, we are trying to reduce any situation where someone is behind a closed door in a cell for any lengthy period of time. And that's the way it is in Charles County. 6 hours a day, 8 hours a day, whatever I can get you. Sometimes a unit may only have 2 people in it. Sometimes I can let them out together. They can have the whole 15 hours a day.
Okay.
So
Sorry, go ahead.
we're just constantly managing it depending on the space, the numbers of people, the situation with each inmate, you know.
Right. Okay.
And not all local jails are central processing, but majority are central processing. So a person will come into our jail and they have to come in, held to see the commissioner, held to see the judge the next day. Most people, 65% are released within that first 72 hours of incarceration. However, if they're held in restrictive housing due to suicide ideation, detox, or medical, or whatever, that's counted. So, I mean, I book in 4,000 people in Calvert County in a year, but my jail population is 100.
Right.
So it's a constant tick, 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 tick in restrictive housing, but that's not people staying in restrictive housing or being in my facility for the entire year. It's just, it ticks up pretty quick, but you're going to report it as you're stated to report it.
Okay. Right. Anybody else?
Also, you got to understand too, with COVID, we are in a congregated living environment. So 2 inmates positive is an outbreak. It's a pandemic. So that unit is going to be restrictive. They're going to be out one at a time, so we won't be spreading so a lot of that got to do with the numbers also.
Okay. All right. Thank you so much.
Thank you.
All right, Delegate Williams, please. And this will be the last question for this panel.
Okay. I'll try to keep this really quickly short. We had a lot of conversation about the limitations as it relates to the whatever you want to call it, solitary confinement, whatever. But there's also a component to the bill as it relates to training. And I haven't heard any commentary whatsoever about the training component to this bill. Is that something that you all are also in opposition to?
For the most part, especially in Carroll County, we do that training in our.
Can you, I'm sorry, just the mic, so it's on the record.
I'll speak for Carroll County. We do that type of training anyhow right now. We do that for our in-service. We have all kinds of traumatic training we have CISM training for our staff, and so we take care of those issues now. So that part of that bill, right now, we are covered. On the other levels,
well, I would say this. I've punched some numbers on that, and I believe you're probably going to hear testimony from one of our other wardens here in regard to that. But you know, I'm looking at $250,000 to $300,000 just for the 40-hour week. Now, you ask me why? Because 100% of it is going to be in overtime because I'm down a third of my staff. I don't have any opportunity for them to train that many hours without them all being on overtime to do it, to accomplish it. So there is going to be a cost, no doubt. But I go back to what Colonel Shrine said. We have evolved in our training. We do train in crisis intervention. We do train in suicide prevention annually during our in-service. They receive it at interest level training. This is stuff that we put a lot of emphasis on because we're dealing, I want to get off topic, but where are efforts? This committee, this delegation, or this legislature, we are dealing with a huge problem in the state of Maryland where we are holding people who are mentally ill that a court order says they're supposed to transfer to the Behavioral Health Administration within 10 days, and it's not happening. And the backlog today, right here today, of just mentally ill persons that are ordered to go to the Behavioral Health Administration is probably standing at 100 to 120 people right now, just from the detention centers. There are no beds. And there's a backlog of 160 to 200 that the Department of Health is trying to move out of the hospital on discharge so they can open the bed space. That problem has been going on for 15 years, and we're the ones dealing with it. And there seems to be no movement and no appetite to fix that problem in the state of Maryland. It has got to be funded. It has got to be planned. It has got to be fixed.
Right, no, I get that piece. I was just asking about the training piece, which is annual, so you would be spreading that 40 hours out over a 12-month period. So, okay, you answered that. And then I know that the sponsor of the bill had mentioned, all of you guys are local individuals. You guys are wardens for local facilities. I think the sponsor mentioned that she's actually putting in an amendment to exempt you guys out. So, just trying to figure out if
Just for
there's
this
still
time, though. That means you made the comment at this time.
Mhm.
So we've been coming up here battling restrictive housing for the last 6 years. And we've had many talks with the mental health community because the attack initially was on the way the mental health people are treated in local jails. And that's correct. We testified our own self that, hey, they need to get out of the jail. We don't have the facility. We don't have the staff. We don't have anything. But when the law says they'll be moved in 10 days and they're there for 57, they're there for 60 days, we have to do the best we can with what we got. So we kind of joined forces in the lobby out here a couple years ago.
Right.
And so that's how locals are starting to get out of it. But we just wanted to take the opportunity to kind of say what we do in general across the board with a multitude of facets of population. We have to take every inmate that shows up at the door, regardless, whether it's the most minor crime or the most heinous crime committed in that county, whether they're mentally ill or whether they're sicker than a dog. We don't have the choice to veto. We got to bring them in, and we got to do the best we can in the limited space that we got in order to keep them as safe as possible at that time.
No, I get it. I just was asking, just procedurally, if you're still in opposition, which it sounds like you're not, but you're just trying to lay a foundation if there's a future bill. So thank you.
Thank you.
I'll follow up on that. Just to be clear, is that your position? Is it the position of the counties that
We
you're
oppose.
We oppose.
you're opposed? But if you were not in the bill, if you were not covered in the bill, are you still opposed?
Still opposed.
All right. Thank you very much.
Thank you.
Here we go to the next panel. Lamonte Cook, Michael Cronise, Melissa Lambert, Daniel Lasher. That'll be the second of the three panels. Then we're going to hear from, after this panel, Mr. Galbraith, Mr. Givenden, Mr. Merritt, Mr. Pesterfield. Let's see who we have on this panel. I see three. I called four, so if there's not a fourth, I'm going to go ahead and call. Are they getting the fourth?
No, she's across the street.
Well, that's a mistake. Well, we'll let her get a chance to come back, but let's, so you're talking about Ms. Lambert is not back? Ms. Lambert?
Yes,
She's
yes.
across the street. Is Mr. Galbraith out there? Come on up. And I've said Mr. a lot, and you all have ranks. I just can't tell from here, but whatever. I apologize broadly. Let's begin it here on my right, your left, and move across. Everybody for 2 minutes. We'll give Ms. Lambert the opportunity to come from over there. Thanks.
Good afternoon, Mr. Chairman, and to the committee members here. My name is Lamont Cook. I'm the Director of Corrections for Queen Anne's County on the Eastern Shore. You've had some members up here talking about a couple of the items that I might address, but I'm going to be more specific when we talk about discipline. And I'm truly aware that we want to do due process when we deal with our people that are in our custody. All managed officials have written policy and procedures which address the establishment of a disciplinary hearing by an impartial individual or committee of individuals not directly involved in the incident, which requires inmate receipt of written notice noting the incident and specific violation or violations within 96 hours of the alleged infraction. The offender appearing at a hearing within 9 days, excluding holidays and weekends of the alleged infraction. The infractions are set in a tiered system where you have major and minor infractions. This is done not less than 24 hours after notification of charges. The offender is given an opportunity to request and have witnesses, to have representatives, to make statements on the offender's behalf, and to present documentary evidence. And also, when we talk about the 96 hours, that excludes weekends and holidays. A record of the hearing and the decision and the rationale that's provided, a review by the managing official, the warden, or somebody designated of the hearing decisions, that may be adverse to the inmates are reviewed, and if there's any discrepancies in that hearing, then we will, the managing official will come back and change what's needed or correct it. A notification of an appeal process. Any action that is taken in the hearing, the inmate is allowed to appeal it. And a report of all hearing decisions to the managing official or designee, and maintaining a written hearing on file. So all those things are maintained on a record for later reference if need be. The establishment of this process helps our agencies to create a safer environment by eliminating potential for disturbances, disorders, and helps to ensure officer well-being. This is all laid out
to wrap up your comments
by the standards, so I wanted to address those. Thank you.
Thank you. Go ahead, sir.
Good afternoon. I'm Major Michael Carnice. I'm the Assistant Warden at the Frederick County Adult Detention Center. Thank you for giving me the opportunity to express some of my facility concerns with this bill. Start with training. This bill will require an additional 40 hours of specialized training for all staff involved in the supervision of segregation inmates. Initial training of all current staff would be approximately $180,000. The additional week of training for the academy for new recruits would be approximately $14,000 annually. This bill also requires 40 hours of specialized training for staff involved in disciplinary hearings, which would be approximately $7,000 annually. The cost of all the required specialized training would be approximately $201,000 for the first year and $52,000 for every year thereafter. This cost is only the overtime cost, does not include the cost to pay a subject matter expert to train the staff on the subjects detailed in the bill. The instructor cost is unknown. My facility overtime budget is $277,000 a year. This training would account for 72% of my entire overtime budget annually. Housing issues. The definition of restricted housing means anywhere not general populations, not in general population. What will we do with mental health inmates, medical inmates, protective custody inmates, and inmates that are on the MAT program, which is a state-mandated program? Physical plan issues. To comply, Frederick County would need to go to the next phase of construction to build additional housing units 10 to 15 years ahead of schedule. The cost is over $25 million at this time. Every facility is different with their own challenge, and all of them are built differently. Staffing attrition issues. Currently, I have 23 vacancies. That's 25% of the security teams. If this bill creates a more dangerous work environment, how do we recruit anybody that will work in a jail? As written, this bill would hinder every facility's ability to protect the inmate population from dangerous, violent inmates or separate persons who are mentally ill or detoxing. Facilities would not be able to separate youthful offenders, which is required by federal law under the Prison Rape Elimination Act. It creates excessive liability for the agency. Because of the fiscal impact and other issues raised, the Frederick County Sheriff's Office is opposed to House Bill 385. Thank you.
Thank you. Good afternoon, and thank you to the chair and the committee members for this opportunity to speak. I'm Captain Daniel Lasher of the Allegheny County Detention Center. Just for the record, a couple years ago during a drought, my moat dried up. COVID took my dragon, and I haven't been able to get one to apply. So, within every local correctional facility in the state of Maryland, there exists a large segment of the inmate population that requires additional supervision, adjustments to programming, and very often special housing. I'm speaking of those with mental illness. I manage a facility that currently houses 188 inmates. 97 of the inmates in my population are on psychotherapeutic medications. That's over half my population. Many manage their condition well, and their medications assist them to function within the bounds of normal behavior. However, there are those who, even with medication, cannot control their behavior. Some refuse to take their medication, and their behavior is also unacceptable, not just to the staff, but to the other inmates in the facility. A sampling of the behavior I'm referencing from incidents over the past year in my facility alone are consistent screaming and yelling of racial slurs, hours upon hours through all day and all night, beating their heads against the wall until they're bleeding and both eyes are blackened, repeated kicking of their cell doors for hours and screaming, repeated spitting in the face of correctional officers each time they see a correctional officer, throwing urine on staff as they're attempting to feed the inmates, flooding their cell and putting feces on themselves to inhibit the staff from touching them. Now, these are just a sample of the behavior my colleagues and our staff witness regularly. These things happen every day in all facilities. not on a wide-scale basis, but consistently. If it's not once or twice, but out of 23 jurisdictions, it's very common. So a reasonable assumption is that these individuals would be quickly deemed to need psychiatric assistance beyond what is available in a local institution, and you would be correct. However, this does not happen quickly. Petitions are filed for, evaluations are scheduled, and eventually there are commitments issued to transfer these people to the Maryland Department of Health and Treatment. And I will finish quickly by saying I've had people since October and November who were committed to the Maryland Department of Health. They have no beds. And they have no beds for the people they have that need to be released to go to step downs. So these folks need to be restricted for some period of time for their safety and the safety of others. We watch them very, very carefully. Thank you for your time.
Good afternoon. I am a very visual person, so after my testimony, if someone would like to look at a couple pictures of our restrictive housing, I have them here to show. Good afternoon, Mr. Chairman and committee members. I am Warden Daniel Galbraith of the Harford County Detention Center. I am here today in opposition to House Bill 385. We at the Harford County Detention Center pride ourselves in providing quality incarceration to the inmate population committed to our care and custody. Part of quality incarceration is treating inmates with respect and dignity, providing them a safe and secure housing. House Bill 385 will severely hamper our ability to provide safe and secure housing to all inmates. All local detention centers in Maryland are faced with housing inmates with severe mental health disabilities and diagnoses. Many of these inmates have been deemed incompetent and are ordered by a judge in either the Circuit or District Court of Maryland to be transferred to the State of Maryland Department of Mental Health. The court order states the inmate be transferred within 10 days to their care and custody. We immediately contact the admissions office for the department and are told they have no beds available and they cannot take the inmates. Most inmates are held in our detention center for several months past the 10 days allotted time for the transfer. I have personally spoken with the judges in the Circuit and District Court and the Office of Public Defender's attorneys, as they are normally the attorneys representing the inmates awaiting a bed in a state hospital, requesting their assistance. Due to the severity of the mental health conditions affecting the inmates, we see them deteriorating while they await placement. House Bill 385 will not allow our special confinement team to safely house the individuals that are a danger to themselves or others. If you want to help the inmate population that are truly in need of your assistance, I ask you please do not grant a favorable status to this bill. I beg you to please inquire why the State of Maryland Department of Mental Health can knowingly defy a court order to receive the inmates ordered to their care and custody.
Delegate Kaufman.
Yes. Maybe it's just Valentine's Day or something, but I'm very confused by the level of opposition to this bill from county officials, since Delegate Bartlett has generously offered an amendment that would exempt all of you from this legislation, yet so given that it won't affect you and your practices under the Bartlett Amendment, can you educate me as to why you all are still strongly opposed to this legislation?
This legislation, sir, was submitted, and we gathered and we spoke about it as a association, and it wasn't until we were down here prepared to testify and be heard that this amendment was advised to us. If we were told weeks in advance that this was not going to advise us or to affect us, then maybe you wouldn't have this group that are adamantly opposed to this legislation. It wasn't until that the other side saw that we were down here and so committed to the well-being of our inmates that are in our care and custody that they realized, because the Department of Public Safety may not be, because they are a state agency, be able to be down here testifying.
Well, thank you, and I'm sure Delegate Bartlett drafted it as expeditiously as she could. Thank you very much.
Thank you, Mr. Chairman. Thank you, gentlemen, for coming in to testify. I was curious, the way the bill is written, does the term restrictive in restrictive housing mean one person in a cell? Anybody can answer.
No, I believe it's different in all institutions. I mean, there are times, I believe most of us, or I'll speak for myself, we try to keep probably 2 to a cell, but it depends on what the individual's there for. Again, if they're violent and we don't feel that it's safe to put them with someone else, or if they're on protected custody. Quite often, if you get a high-profile case of, say, someone who is a pedophile, it's not safe often to put them with someone else for their own protection, and they generally ask for it. I have regular inmates, as they all do, that I think you'd be very surprised if you looked at the population in your local facilities. I've got people who've been there 30, 40, 50 times. They get arrested consistent. Sometimes they're there for 2 months. Sometimes they're there for 12 months.
But they're not normally there
But-
in a cell by themselves.
Well, no, what I'm saying is, but some of those people come in, and every time they come in, the very first thing they ask for is that, because they'd like to have a cell by themselves.
Sure.
But we try to put them with someone else, because we all have
What I'm
space
trying to get to
confinement.
is your opposition to the bill, and I believe that you're looking at the term restrictive and restrictive housing as a one person in a cell versus it specifically being double celled. Is that correct?
No, I don't believe, no.
So you could have
We could have
people
2
in the
people that
cell.
are restricted in the same cell, absolutely, because space demands it. So we would still have to follow the same rules as are written in that bill for those particular.
So then following the rules that are written in this bill becomes a problem because at some facilities you're down 25% on the employees. Is
Well,
that
the
right?
staffing's one issue, and my issue, that it's not as much, I have a unit that has 12 cells. Getting each one of those people out, as one section of that bill said, for 4 to 5 hours a day for programming, I can't do it individually if they can't be together. So if I've got, these people cannot be with one another. Again, if I have someone there who is vulnerable, I can't bring that individual out with someone else. If at any point during their incarceration, there's someone that we feel safe they can be with, and we put them in that cell with them. But there aren't enough hours in the day to get them out for, individually, for that many hours at a time, and it's an attempt. And one of the, I wanted to mention to the delegate who was asking earlier about the statistics for COVID, something that threw that off, and I ask you to please sit back and look in 2 years when we post it, because quite honestly, COVID destroyed those statistics. Many of us reported restricted housing for a great deal of our population because much of our entire jail was locked down.
Okay, thank you very
So
much.
you're quite welcome. Thank you.
And I just wanted to add just quickly.
Very quickly.
Yeah, very quickly, that I run a smaller institution than many of these operations that are represented. And I have a gentleman now, if you talk about being in a restrictive situation, he will fight. We couldn't leave him in a cell with another individual, but every time the officers open that cell or pass a meal into him, he tries to punch him. He tries to assault an officer.
So therefore, this person, as described earlier, he wouldn't be a sheep, he wouldn't be a wolf, he would be a super predator. He would be one of the ones that controls the 10%. He would be the 3% of the 10%.
Right.
Is that correct?
Right.
And that particular type of individual, if I think the average prudent person was dealing with them, they would be confined to restrictive housing. Isn't that correct?
They'd be confined so they don't hurt
Yes.
anybody else.
Thank you very much.
Seeing no further questions for this panel, we thank you all very much. Give the last chance for Melissa Lambert to speak on this bill, Donald Givenden, Guy Merritt, Walt Hesterfield. Starting from my right, your left, go ahead for 2 minutes.
I'm Major Donald Givenden, Assistant Warden of the Harford County Detention Center. I'm here today on behalf of Sheriff Jeffrey R. Gaylor and the Maryland Correctional Administrators Association to oppose House Bill 385, pertaining to restrictive housing. This bill will be detrimental to operations at all adult detention centers in the state. Our adult detention centers are required to follow the Maryland Commission on Correctional Standards. Within those standards, special confinement is addressed in Section 01P. The standard states that managing officials shall have a written policy and procedure governing the placement, removal, supervision, and rights of an inmate assigned to administrative segregation, disciplinary detention, medical isolation, and protective custody status, which includes provisions for, and I'll paraphrase, identification of persons, designation of circumstances, specifications of timeframes, access to service and programs, maintenance of supervision, and records. It also says within the standard that separation from general population is only to be used when there is no other viable alternative to protect the inmate, staff, public, property, and facility security and order, and then only to the extent necessary to return the inmate and facility to normal. In my facility, we take a multidisciplinary approach related to restrictive housing. Security staff, classification counselors, medical and mental health professionals review each inmate assigned to special confinement on a weekly basis. House Bill 385 is in direct conflict with the already established standards. It certainly will decrease the safety and welfare of our inmates and staff by taking away disciplinary detention. I'd like to give you an example. I currently have an inmate who's in my jail for the 40th time. He is without a doubt a career criminal who is currently charged with armed robbery, assault, theft, and fraud. Since his booking date of 11/22, he has been involved in 3 assaults, 2 threats against staff, 5 disorderly/refusing order incidents, 1 destruction of property, and 1 possession of contraband. But most notably, he's been involved in 8 incidents of throwing feces and/or urine. I've brought some photos along if you would like to see them. House Bill 385 would only allow me to place such an inmate in restrictive housing for no more than 60 days in a 365-day period. The inmate I'm referring to has only been in my facility for 85 days as of today, and you see what type of behavior he has displayed. Imagine what he will do after serving 60 days in restrictive housing, and he knows that there will be no future disciplinary detention for the remainder of the year.
Thank you. Next, please. Go ahead.
Good afternoon, Mr. Chairman and members of this committee. My name is Walt Pesterfield, and I'm the Director of the Baltimore County Department of Corrections and Detention Center. I'm speaking on behalf of the Baltimore County Department of Corrections and the Maryland Correctional Administrators Association. I'm here today in support of MCAA in opposition of House Bill 385. Baltimore County Department of Corrections has the largest capacity of any detention facility in the state of Maryland and our current population of 1,037 inmates. Of those 137 offenders, 33% or 342 offenders would be ineligible on age alone for restrictive housing based upon this bill. Baltimore County Detention Center in December 2022 indicated 34% or 366 offenders would be ineligible for restrictive housing under this bill. Baltimore County effects of the House Bill 385 in regards to training. 40 hours of training initially for each employee, that's 243 total employees currently at 8 hours of training annually would cause approximately 10,000 hours in overtime per fiscal year, implemented in approximately 2,000 for each fiscal year thereafter. With an average overtime rate of $46 per hour, overtime costs would be $460,000 for the first year and $90,000 thereafter. I'm going to talk a little bit about the mental health piece of it and what we do at Baltimore County. Average inmate population diagnosed with mental illness is between 30 and 35% for 1,000 inmates. We have 5 full-time mental health staff working 5 days a week, 4 part-time working weekends, plus an on-call psychiatrist. Inmates on segregation diagnosed with mental health illness are assessed by mental health staff and deemed not to be compensated while on unit. Mental health staff conduct rounds Monday, Wednesday, and Friday on restrictive housing. Inmates on suicide watch are seen daily by mental health staff with 15-minute rounds by officers.
Can you please begin to wrap up?
One more statement. If this bill is passed into law, it places detention centers in a position that will endanger the safety of the security of each and every detainee, correctional officer, and employee who enters our facilities. It would have no positive effect whatsoever on protecting the vulnerable and would actually place detainees, inmates, as well as correctional officers in an extremely dangerous position. Thank you.
Thank you very much. Sir?
Good afternoon, Mr. Chairman and committee members. My name is Guy Merritt. I am the Deputy Director for the Bureau of Administration at Prince George's County Department of Corrections. And I'm here with my colleague to represent in opposition of the bill, as it will hamper our efforts to apply mental health and correctional best practices in our facility. We understand that health and welfare of each inmate is positively affected by housing the individual in the least restrictive and most appropriate environment possible. Our overarching goal is to successfully move individuals as quickly as possible to the least restrictive environment possible. Our hearing process is timely, requiring classification staff to complete hearings within 72 hours. Our classification and inmate service teams use behavioral modification plans to offer incentives to accelerate movement towards least restrictive housing environments as a reward for positive behavior and engagement. The inmate is invited to collaborate on learning opportunities and strategy development that may foster sustained positive change. For inmates with histories of multiple disciplinary infractions and subsequent moves to disciplinary housing, a multidisciplinary approach is used to determine if there are issues perhaps undiagnosed by medical staff or other behavioral health clinicians within PGDOC to provide additional counseling and case management resources. The department routinely experiences individuals who are in disciplinary segregation on repetitive behavioral infractions that are often violent in nature. However, the classification staff reports weekly on all hearings, and with those who have sanctions which call for the individuals to remain in disciplinary housing for more than 30 days, to provide an audit trail that ensures disciplinary segregation is used appropriately. Thank you for listening.
Are there questions for this panel? Delegate Phillips.
I've been pretty quiet today, Mr. Chairman, but I'm trying to understand this. For Baltimore County, on any given day, what's the average number of persons that are on restrictive housing with 1,000 inmates? Can you tell me?
Excuse me?
What is the average number of individuals in a 1,000-person facility? Is the average number of persons that are in restrictive housing?
We're going to have about 30%.
30%? And of that 30%, can you break down those who are there because they're, some type of mental disturbance versus disciplinary?
I don't have the percentages, but I can tell you on a daily basis, we average 50 to 55 that are on suicide watch, that are placed on that by our medical team. We have an array of individuals placed on restrictive housing, from sex offenders to individuals that request because of concerns of safety. That is our highest numbers and percentage. The lowest numbers is for disciplinary action. I think our units, let me have a number here that might help out a little bit.
And while you're looking at that, approximately how many spaces do you have that would be considered restrictive spaces that you could put people in?
Well, we have 2 housing units.
And I guess my question is, are we filling those restricted spaces on a daily basis?
Well, they fluctuate, because we may have a time where we have 20% and maybe a time where we have 35%. It all depends on the population, and our suicide watch, that can fluctuate very vastly depending on when that's taken off by our medical.
It seems to me that the definition, I'm struggling with the definition of restrictive housing, not only in what it looks like physically, but whether we are consistent across the board with how we define in each jurisdiction and maybe at the state level what that is. Because I've been kind of trying to understand this and looking at a number of studies from other states. And it just seems like we don't have a very consistent view of what restrictive housing is. Would that be a fair statement?
And I think you're kind of referring to restricted housing versus discipline versus these other actions such as suicide or protective custody and whatnot.
I understand your question, too. If I could just chime in with, there is different, you hear different definitions today of admin segregation and disciplinary and protective custody, but I think the important line in this bill to focus in on is it says that anything that is not general population is restrictive housing. I mean, that's right within this bill.
So that's why it does tie our hands. There are different categories of things, and this will prevent us from protecting people to the best of our ability because of that.
Are there any, once a person is in restrictive housing, are there any kind of third-party, is there an opportunity for someone else to come in and question that individual being in restrictive housing outside of your facility? Does that happen?
Well, within the facility, there's an appeal process, and that
I understand within,
Right.
but I'm saying, is there just a natural, as a stakeholder, as a family member, and I'm wondering if, you know, we're looking at an ombudsman bill. If that became one of the things that the ombudsman looked at a regular basis, would you have any objection to that?
Well, I think to answer the first part of that is, and we heard the testimony earlier today, that by the standards, and we are inspected, you know, audited every 3 years on those to ensure that we are providing a safe environment.
And I understand the 3 years, but I'm now in
Yeah,
I'm
but
now in solitary confinement or
daily
restrictive,
basis.
whatever, right?
I understand.
And I've been in there for 10 days. There's a question is whether or not anybody in the correction system has communicated with anybody outside of the correction system. I'm in there for 10 days, but nobody's looking at me. Right? I listened to the young lady earlier who said, you know, she had been in a restrictive confinement for 4 years. It's a long time. So I'm just trying to understand, would you have an objection if there were another process besides just the individual's appeal process?
I think that collectively would be an association thing that could be talked about. I wouldn't want to make that decision or say that for myself, but I think that's something that could be talked about.
All right. I think I'm done.
Thank you, Mr. Chair. This is for Baltimore County. You know, you mentioned a few statistics. I appreciate those. I'm running into some problems. Looking at the dashboard, doesn't align with the statistics you raised. I think you raised that 30 to 35% of your inmates may have mental issues. Dashboard says 0 were placed in solitary confinement as a consequence. I'm not questioning what you reported today. I'm questioning the dashboard, just to be clear. 30% of your folks are in restrictive housing. Dashboard says 9.9%. You said that the least amount of restrictive housing rationale is disciplinary. Dashboard says 100% of your restrictive housing is a consequence of that. So I say that to not just you, but everybody that might be listening from all of the jurisdictions. I appreciate y'all coming today. I appreciate your advocacy. It's very important that we get to, you know, work together and make sure that we achieve everything that we're trying to do, make sure that your facilities are safe and everything like that. But at the same time, this data is critical, and it's clear to me, at least in Baltimore County, and when I look at other places, and I can highlight other places I've been dabbling around in, that there's a real problem with data reporting. And when we don't have a clear picture on this committee, we're not going to be able to have a clear picture on what legislation needs to look like. So I guess my question is, you know, what might be the rationale or consequence? How did that happen?
I can't really answer that for you myself. It doesn't sound like it matches up, and whether that's input on what the individual, whether it's a suicide individual, whether it's a restrictive housing, you know, or whether it's a disciplinary action. Maybe that's where there's issue. I can't say for sure.
Thank you. I'm just asking y'all to look into that. And then the last question, Mr. Chair, and I'll conclude, is having to do with release back in the community. Looks like y'all have about 75% of your restrictive housing folks, at least according to the dashboard. Now, we have raised questions on the data, are released back into the community. And you mentioned you have a larger population. I imagine many of them are coming to Baltimore City as well when they're getting released. Would you say that that's a large percentage or larger than you would expect?
That would be coming to Baltimore City?
That would be coming out of restrictive housing directly into the community.
I couldn't say that for sure. No, I wouldn't. I would be out of line to say that.
If you all could, you know,
We can sure look into that.
I would
Absolutely.
appreciate that.
Absolutely.
Yep.
Thank you, Mr. Chair. Thank you, gentlemen, for coming in to testify. To the gentleman who's just speaking, can you just really directly say how passing this bill will create an extremely dangerous environment to the employees? Just briefly and quickly.
Well, when you're not able to put people that should be in restrictive housing, just say, for instance, when you mark out all individuals that are 26 and under or 55 and over, and you say they are not eligible to go in restrictive housing, and you have an individual that is extremely violent, as some of the other wardens have described, and you have to put that person in general population, that could be.
And real quickly, what percentage of the inmates are 26 and younger?
I don't have that, but I think there's a large population between 18 and 26.
Thank you so very much.
Seeing no further questions, that concludes the testimony now on House Bill 385. Thank you all very much. We're going to move now to House Bill 97. And 23 witnesses. Delegate Bartlett's bill, we'll hear from her for 3 minutes, then Darrell Hale, George Townsend, Elizabeth Hilliard, DeAndre Wiggins. We're going to leave the fifth chair out there.
How you doing?
Again, Delegate Bartlett, Mr. Hale, Mr. Townsend, Ms. Hilliard, Mr. Wiggins. Who do we have up there? Who are the two? Mr. Wiggins cannot make it. We'll go to Gary Boehner. Mr. Boehner? Go ahead, Delegate Bartlett, for 3 minutes, please.
Thank you, Mr. Chair. I'm Delegate Sandy Bartlett, representing District 32 in Anne Arundel County, and I'm presenting House Bill 97, also known as the REDEEM Act. What does REDEEM stand for, you may ask? It stands for the abbreviated version of Record Expungement, designed to enhance the employability for the 1.5 Marylanders, REDEEM, who are shut out of the workforce due to a criminal record. So the provisions of the REDEEM Act align with what most other states are doing, regardless of their political affiliation. Everyone must work. Everyone must work if they expect to support themselves and their families. And Maryland law shouldn't be the reason returning citizens are locked out of employment over a decade after they have completed their time. Also, the REDEEM Act will help bill some of our favorite Marylanders, taxpayers. A criminal record can be both the cause and consequence of poverty and has detrimental effects on the employment prospects for the estimated 25% of working-age Marylanders with a record. Every year, approximately 15,000 Marylanders are released from state prisons and struggle to secure a job, find a place to live, and re-enter into society. Demographically, 71% of Maryland's prison population is Black and the highest in the nation. And one out of 3 Marylanders returning from incarceration return to Baltimore City. The Department of Justice has found high rates of recidivism among returning citizens, with half of all returning citizens recidivating within 3 years and 60% recidivating within 5 years. One of the primary drivers of high recidivism rates is the inability of returning citizens to find a job. So, members of the committee, I ask you for a favorable vote on House Bill 97. You will hear testimony today of individuals who have experienced exactly just what I just stated, and that is inability to find a job even after the sentence has been served. Thank you so much for listening, and happy Valentine's Day.
Good afternoon, Mr. Chairman, Vice Chair, and committee members. My name is Darrell Hale, and I'm a member of the Maryland Alliance for Justice Reform. As a member, I strongly support House Bill 97, which reduces waiting periods for expungement. Maryland's expungement law as it currently stands is a dream deferred at best and a pathway to homelessness, unemployment, and hopelessness at worst. With waiting periods of 15 years to 10 years respectively for felons and misdemeanors, returning citizens face imminent and immovable structural barriers to successful reintegration to society. We may not say it out loud, but an ex-offender knows the unspoken message. Once a criminal, always a criminal. Most ex-offenders know it will be an uphill battle to leave their criminal history behind and start over. They hear the unspoken untruth as a subtext to every unexplained denial of employment, to every unexplained reason for selecting another applicant for an apartment, to every unexplained occupational license not approved, to every unexplained loan not granted. And that subliminal message of once a criminal, always a criminal, over time can take a debilitating psychological toll on many returning citizens. The facts are clear. As many as 1 in 3 Americans have a criminal record. Maryland's recidivism rate is 40.5%, meaning 6 out of 10 ex-offenders do not reoffend despite unreasonably long waiting periods. The 3-year prison return rate, which is a measure used by the Bureau of Justice Statistics, dropped from 50% to 39% in 2017. People age out of crime, with people age 40 or older reoffending 36.3% of the time compared to 64% of the time for people aged 24 or younger. Within a year of expungement, ex-offenders' wages increased over 22% as a result of finding stable employment. For all those reasons, I request that we support House Bill 97.
Mr. Chairman and members of the committee, good afternoon and happy Valentine's Day. My name is George Townsend. I'm an attorney at the Maryland Volunteer Lawyer Service Workforce Development Project. My project provides free legal services to participants in workforce training programs, and the most common service requested of us is criminal record expungements. My expungement clients come from a wide variety of backgrounds and communities, but they all have exactly 2 things in common. One is that all of them are actively seeking gainful employment, and the second is that all of them are hindered in obtaining it because background checks reveal lingering criminal charges and convictions, often from years in their past. The wait times to expunge eligible convictions in Maryland are currently 10 or 15 years, depending on the specific charge. And importantly, this waiting period only begins to run after the completion of the entire sentence, including any incarceration and/or probation assigned by the court. This is an enormous period of time after punishment has already been completed, before these individuals can do the things that we as a society want and expect them to do, things like gain stable employment and settle into long-term housing. Preventing them from doing so is a burden on those individuals, and it harms the economy and the communities of Maryland as a whole. As Delegate Bartlett alluded, the wait times in Maryland are dramatically out of step with the rest of the nation. A report by the Collateral Consequences Resource Center found that of 43 states that have a process for criminal record expungements, Maryland is the very last in wait time as far as misdemeanors go, and as far as felonies, our wait time is tied for last with only North Carolina. This bill brings Maryland dramatically closer to the national median. It removes an enormous burden in the path of those trying to start a new life, and it benefits the state of Maryland as a whole. I thank you for the opportunity to testify, and I respectfully urge a favorable report.
Oh, I can just slide down. Let the music stop.
Mr. Chair, I forgot to mention that there is an amendment on the record for this bill.
All right, we'll get to that in a minute. Let's go with Mr. Deuce.
Fantastic. Christopher Dews, representing the best interests of the Job Opportunities Task Force. Going to do my best not to repeat what has already been said. Just wanted to highlight again, 1.5 million Marylanders have a record that would appear on a routine background check. That's Bureau of Justice Statistics. And primarily the individuals that are going to be most impacted by these records return to both Baltimore City, Prince George's County, and Baltimore County. That's the first thing I wanted to highlight. Second thing I wanted to highlight is that when an individual has a criminal record, according to SHRM, 85% of employers conduct a background check and will deny employment on the basis of a record. They're not necessarily doing anything wrong, but that's just how criminal records work in the state of Maryland. And we found that 50% of job offers are basically cut. About half of job offers are cut if an individual has any prior conviction of any charge whatsoever. And so what this bill simply seeks to do is reduce the damage that comes from having a criminal record. I want to highlight again what the gentleman from MVLS said. This is after an individual has served their entire sentence, done parole and probation, as well as any type of mandatory supervision. This can get a little confusing. You may hear opposition testimony saying something different, but this bill waits until the person is completely free and back on their own and now have to get themselves reacclimated back into society. Having a record blocks access to housing, employment, public assistance, occupational licensing, and more. And if an individual can't get access to food, housing, education, licensing, and more, and employment being the number one thing, how are they supposed to survive here in the state of Maryland? Not to mention, for misdemeanors, you have to wait 10 years, and that's only for the charges that are eligible for expungement. For the nonviolent felonies, that's 15 years after they have served their time. All this bill simply says is let's reduce that window down to what Oklahoma, Colorado, Kansas, Utah, Kentucky, and Minnesota have already done, very, very liberal states. What they've already done, and we're just trying to bring it in line with other states so more people can get access to employment. Thank you for your time.
Good afternoon, Chairman and Committee. My name is Randolph Johnson. I live in District 45. Delegate Young's district. I'm a participant of JOTF Better Youth Construction Academy. I support the REDEEM Act as a means of reducing the impact of incarceration and enhancing employment opportunities for lower income workers and job seekers throughout the state. I was released in 2003. I obtained a job through a temp agency. I worked extremely hard through that temp agency for years. When I tried for a promotion, even though I had the skills and experience, because of my record, I was denied. Until my record was expunged, I was able to secure that job. Through that, I'm a firm believer in expungements, and for a favorable report. Appreciate you.
We'll take questions for this panel. Are there questions for the panel? Okay. Thank you all very much. We'll go to the next panel then. Okay. Not really used to that today, but okay. Ms. Hilliard. Yeah, that's fine. They got it all out of their system on the last bill. Ms. Hilliard, or is she across the street? Wouldn't shock me.
Maybe across the street as well.
There's another representative from Public Defender. Yeah, come on up. So we'll hear from you. All right. Again, Monica Allen, gone. Monica Allen? No? Jessica Emerson? No? Octavian Thomas? Come on up. Charlotte Ahern? Come on up. Emmanuel Byron? Emmanuel Byron? No? Okay. Could we have Ashley Devon Johnson, please? Not on there? All right, well. Oh, she's here live and in person, so that's fine. We're not supposed to do this. Don't tell Dylan. All right, but it's fine. Well, it was fun while it lasted. Then Lauren Pruitt will bring you up. I thought I saw Ms. Pruitt. Come on up. That's fine. All right, starting from my right, your left, and moving across, go right ahead for 2 minutes.
Good afternoon. I'm Mary Denise Davis. I'm with the Office of the Public Defender, and we're here today in support of House Bill 97. I think the reductions in the time periods are practical, and they make sense. I will try to make this short because I know there's going to hear a lot of people who will benefit from this law. But I think it's important to note that what has been said before, that somebody cannot even start asking for the expungement until everything is completed. And that can be 5, 10, 15 years, and even tack on more if you have to calculate the parole. And I will tell you that it's very hard for a pro se individual to know when that time period is supposed to start. The other thing I will say is that this will allow better employment and better housing. And when I say that, what that means is that the individual that spoke earlier, they were up for a promotion, but they didn't get the promotion. People want to live in another neighborhood for better schools for their kids, but they can't do that when they have this criminal record that's holding them back. I will also say these time periods came about during when the Justice Reinvestment Act became law, and people ask me, why these time periods? I have no explanation of why these time periods were chosen, but I think the reports that everyone has talked about has shown that Maryland is behind the curve, and I think Maryland needs to step up and make the waiting periods a lot shorter. The other thing I will say too, no law is stagnant. No law should stay still. So anybody that says, well, let's just wait, that's not going to help the citizens of Maryland that need help. In addition, I have one more point, but that's it. I do not have a point. So I just want to say thank you, and I hope you have provide a favorable recommendation.
Good morning. My name is Octavian Thomas. I'm also a part of the JOTF Better You training program. And I just wanted to state that, this is in regards to the testimony support of REDEEM Act. My name is Octavian Thomas. I support the REDEEM Act as a means of reducing the impact of incarceration and enhancing employment opportunities for lower-income workers and job seekers throughout the state. This is a great concept for those who may have fallen victim to the justice system, such as myself and others. It is a grave hindrance to those seeking gainful employment and ways to sustain a good standard of life. For instance, I think that it is unfair to constantly use a person's past criminal offenses in regards to future events. I have a criminal history that included drug offenses. I served my time that was done 8 years ago. Because of this past, I can't move on. I have personally been going through this and being held back because of my past for a great deal of my life. It even followed me to traffic court recently. For instance, I just had a traffic case, and the state's attorney kept making reference to my background, which depicted me as a constant lawbreaker, their exact words. The current system and this type of attitude have affected my life, outcomes, and prospects when all I was charged with was driving on a suspended license. It is totally unfair that after I have served my time and am no longer in that same lifestyle that I once was, that I continue to be punished when this is over. This is why I feel the REDEEM Act is necessary and should be highly considered. For these reasons, I urge a favorable report of the REDEEM Act. Thank you.
Can you hear me? Hello. Thank you, Chairman Clippinger and members of the committee. My name is Charlotte Ahern. I am a staff attorney at Maryland Legal Aid. The majority of my work focuses on workforce development and criminal record expungement. As you know, this reduces the time frames. This will not only drastically help constituents in each county, this will drastically help the state of Maryland through income taxes. It's been mentioned many times, we're far behind the times. The fact that we're behind Texas, Utah, Mississippi, Oklahoma, that's not consistent with the state of Maryland and the legislature's goals. A couple of things to note, to be clear, this does not increase the types of it does not increase the type of convictions that are eligible. These are convictions that this legislative body has already deemed eligible after 10 to 15 years. Also, there's specifically a carve-out for domestically related crimes. I just wanted to note that. The majority of my clients I hear again and again and again is that they are being punished twice. They do their time, they serve their time, and they try to come back to the community, but they're being punished again by waiting an additional 10 to 15 years, which I think that's really the antithesis of our judiciary system. Just to provide a quick example from Garrett County, and it's similar to Mr. Thomas's situation, a client of mine was convicted of CDS possession with the intent to distribute on August 25th, 1986. To give you some understanding, I was 2 days old. I was 2 days old when this man received this conviction. He'd waited 15 years, and just 2 months before that 15-year time frame had almost expired, he received a driving on a suspended. Because of that driving on a suspended, 15 years later, both of those convictions cannot come off his record. And if I could quickly note, thank you, that the fiscal note says that this will have very, very minimal impact in terms of how much it will cost, when the actual financial gain from gaining income taxes through people being employed will be significantly higher. So I urge a favorable report. Thank you. Sorry.
Do you want me to?
Yeah, I can do it then.
Good afternoon, Chair and members of this committee. My name is Ashley Devon Johnson, and I am the Research and Policy Coordinator for Out for Justice. Out for Justice is a nonprofit organization that is comprised of individuals directly impacted by the justice system, and we advocate for changes in policy that adversely impact individuals' reintegration back into society. When I left this particular committee before COVID, I was here talking about the youth justice impact. And I told you all about this wonderful report by the Public Justice Institute, and it talks about how Maryland incarcerates more black men than any other state in this country. We also, we led in this particular report 25% more than the state of Mississippi. Now, when we look at the fact that Maryland has incarcerates the most amount of emerging adults, and that the primary amount of those are black men, I come back with 3 OFJ members who are 3 black men who received charges in between the ages of 18 and 21, who have served years in prison. And I want you all to remember this phrase: once a criminal, always a criminal. If we do not pass the REDEEM Act, we are essentially saying that all of the dangerous policies and practices that we had in the past are okay, and that it's subsequently okay to say that some people will never be able to gain full citizenship in this state again. I would like to see this particular bill pass. You will hear from one particular committee member who served 27 years and 8 months and is now serving 18 years on parole. In 15 years, this particular person may not be alive and may live their entire life without being able to not be discriminated against for housing and for jobs. I think the time to pass this is now, and for all those reasons, we urge a favorable report on this particular legislation. Thank you all.
Good afternoon. My name is Lauren Pruitt. I'm the Legal Director for Free State Justice, Maryland's civil rights advocacy organization for LGBTQIA+ Marylanders. I'm here today supporting House Bill 97. Individuals released from correctional supervision face severe barriers to employment, housing, public assistance, and education, as you've heard. For LGBTQIA+ Marylanders, these obstacles to reentry exacerbate existing disparities impacting our community, such as increased levels of poverty, employment discrimination, and healthcare access. Many clients that reach out to Free State find themselves in untenable situations because of the statutory wait time for expungements in Maryland. When they find decent employment opportunities, employers will decline to interview an applicant with a criminal history. Many clients even feel forced into continuing illegal revenue streams to provide for themselves and their families. Clients in abusive relationships cannot leave because they are unable to get housing in their own name, either due to lack of employment income or inability to apply for public assistance. Even opportunities for self-employment are limited because of lack of access to loans and small business programs. By keeping individuals saddled with these stigmatizing records, the state is effectively punishing them twice. Overrepresented populations in the criminal justice system face overcriminalization of their persons and activities, while coercive plea bargaining results in an increased rate of conviction and the unemployment or underemployment that follows. The REDEEM Act shortens the waiting periods for expungements, purposefully removing these employment barriers. Finding work is a crucial step for reintegration in a broader society. This bill not only benefits everyone by removing these punitive barriers to economic mobility, but also benefits the state through increased tax revenues, decreased crime, decreased recidivism, decreased labor shortages, reduced expenses for state benefit programs, and decreased poverty rates. Reducing these waiting periods will open doors to all 1.5 million Marylanders who are effectively shut out of the workforce due to a criminal record. And I come to you all not just as a civil rights attorney, also as a former corrections officer, as a former educational professor of higher education. And for these reasons, Free State Justice urges a favorable report on House Bill 97.
Thank you all very much. There was an amendment that that will be sent around to members of the committee that it would include malicious destruction of property as one of the things that could be expunged that presently is not in the shorter time frame. But anyway, that's perhaps for another time. Okay, I'm going to take questions. Delegate Tolles.
Thank you, Mr. Chair. Just a quick question, gentlemen. What county are you from?
Me?
The gentleman. Yeah.
Baltimore City.
Okay. And the ASA in Baltimore City. Can you repeat what happened?
Well, I actually had a traffic case that it initially was from child support. I had created my own business, Al Hands Cleaning Service. Y'all can look that up. So I created my own business.
I'm not mad at you.
It went into a lapse after 3 months, which was only $600
For child support.
Yes, and they
Interesting.
They
Okay.
suspended my
Sounds
license
familiar.
because of that. So when
Okay.
they suspended my license, I had to get, which I'd done before, a continuation letter of me paying the actual payment, which I did with no intention of like nobody telling me or none of that. So once I did that, I had to do actual driving improvement because they gave me 5 points for driving a suspended license. I did that, completed that, went back to court, and like I said, the state's attorney, she just kept on saying, it kept on making reference about my background. So I was puzzled because I'm like, I'm in here for traffic. What background is she talking about? I don't even have a driver's license.
Okay. No, understood. Thank you for sharing your story. And then, as a quick follow-up, how long had you been out before
Been
that
home
happened?
since 2014.
So, I mean, I'm saying the time frame. When did that happen? It was like 5 years, 6 years?
Yeah, it was about
Okay.
5.
Okay. Thank you. I just wanted to kind of bring reference to, the significance of the bill. So thank you, Delegate Bartlett, for bringing it forward. And that's my questions, Mr. Chair.
This is the question for the woman from OPD. You had a last point that you were trying to make. Just wanted to follow up with you about what that last point was.
The last point I wanted
I'm sorry. I know you guys played do-si-do with the...
The last point that I just wanted to make is that the Redeem Act applies to Section 10110 of the expungement statute, which is different than 10105. So any conviction that's listed under 10110, it requires more review of the petition than under 10105. And what I mean by that is, yes, the state's attorney can object in both of them, but the difference is in 10110, there will be the judge that is going to look at the individual and is going to say, is this in the best interest of of justice? So it's more than just simply, I'm going to file an expungement and it's going to be granted. And that's why I think it's important that we realize, even when you shorten the waiting period, it's still going to go through a review process with the judge. And let's leave it with the judge that can hear all the factors to make that determination.
Thank you.
You're welcome.
Thank you, Mr. Chairman. Thank you, panel, for coming in. To the lady that just spoke, don't think that my question means that I'm against the bill. What happens when a person applies for a job, let's say at a casino, and maybe on the application it says, have you ever been convicted of a felony? And they've had it expunged. Do you have to say that you haven't had a felony, or do you have to say you have had the felony? How does that work?
I think we have banned, they did ban the box. So, yeah.
Yeah, ban the box. They're not initially allowed to ask that on the application.
Okay.
So that's.
Okay.
But I will say, I don't know if this answers your question, and I know that this legislation isn't in front of the session this year, but there does need to be more regulation of the private databases, because private databases are not regulated by the expungement statute, and private databases can disclose information that's been, and so most businesses use private databases, so they keep all the information, so I think that might help too if we have some regulations with the private databases.
Thank you very much.
I won't say it again.
Further questions? I'm sorry, Delegate Valentine.
Thank you, Mr. Chairman. And thank you all for coming in today, as well as the previous panel as well. My question kind of links into Delegate Conway's question. You may have answered that, but it may be just slightly different. We heard testimony earlier today in another hearing, and this is what brought this question to my mind, was employers get very savvy with their applications, and I believe the example he gave was the application didn't say, have you been convicted of? The question is, have you ever been charged with? So my question would be, if they do this changing in wording and employers can use this as kind of a workaround, how would an expungement of a conviction actually increase the opportunities for someone for employment?
I will say, I'm not an employment attorney, but I do think there needs to be litigation on that issue. Because under 10, if you remember, it's a section in the expungement statute that talks about, can an employer ask a question about something that's been expunged? And the answer is no, but I know of no case law that anyone has challenged that. There is no challenge of that. People just say, oh, I didn't get the job, and they move on. But I think there needs to be,
Typically what happens, at least in my experience, is that those types of questions aren't really on the initial application. It's not until an individual actually gets the job, or they're in the second, third interview, and then that's when typically employers will ask what, their various history is. That's just in my experience. If I would hope that, and I know that this isn't the case, that employers would understand being charged with something doesn't mean that you were convicted of it, but I know that that's not the case. But I agree with the Public Defender's Office and Mary Denise about how that there should be some regulation in relation to that.
and Delegate Valentine, Ms. Johnson would like to make a comment too.
I want to say thank you all both for bringing the questions and directly asking about employment. We have 3 OFJ members who will testify in front of you today who also have who had a charge that has not been expunged, but they are also working. Today, we are having a shortage of workers, and if we do not pass this legislation, we will essentially see our workforce decimated because we do not have adequate bodies to fill the open positions that we currently have. I think that this is an opportunity for us to say what is right for Maryland and what is right for our business owners and how do we move our economy forward.
Thank you. Further questions for the panel? Seeing none, thank you very much. We will hear now Nicole Hansen.
She's testifying in JPR.
Oh, boy.
I would also
Okay.
like to say we have one of our members, Kelly, who is
Kelly Sparks, let's go ahead. Come on
virtually joined virtually.
up. Is Kelly virtual? He is virtual?
Yes. Okay.
Do we know? Okay. Let's go. I'll go through the rest of the list. If they're in the building, we'll take them. Yeah. MJ Sutton, Aaron McLemore, Jason Billingsley is virtual. He's here. Come on up. We'll figure this out somehow. Antoine Quarles. Do you
MJ and Nicole Hansen are in the JPR testifying right now.
All right, I'll put a note.
And
Aaron
I'm gonna sit with our
McLemore
OFJ members.
is here. Okay. Kelly Sparks, are they here?
Virtually.
All right, we're going to keep looking. We'll see what we can do to keep looking. All right, we'll hear from the two of you, and then we'll see where we are. So go ahead.
Hello, to the chairman and to the committee. My name is Aaron McLemore. I'm a member and a representative of Out for Justice. I support the Redeem Act, HB 97. I'm 47 years old. I've been on constant supervision, either parole, probation, or incarceration since the age of 18. When my parole is over next year, I won't be eligible for expungement until 2039, when I'm 64 years old. As you can imagine, this severely limits my ability to support myself and my family. I served my sentence and was released in 2015, and I haven't committed a crime since I was 22 years old. I believe that Maryland citizens should have a reasonable opportunity to have their citizenship fully restored. Thank you.
Good afternoon, Chair and members of this committee. My name is Jason Billingsley, and I support the Redeem Act. I'm here on behalf of Out for Justice. I grew up without guidance and support. which led me making a lot of bad decisions. When I was 18, I served 10 years. After I served 10 years in prison, after repaying my debt to society and serving my prison sentence, I returned home, wanting to positively impact my community. If this legislation were to pass, it would help me get better housing and allow me access to better job opportunities in the future. I do not think returning citizens like me need to wait 15 years after serving their sentence to have our fresh start. I made a mistake, I served my time, and now I'm ready to positively help my community. For these reasons, I support this legislation. Thank you.
Are there questions for this panel? Thank you both very much for being here today. It's important that we hear from you on this issue. Thank you very, very much for being here.
Thank you.
All right, we will go on, and if people walk in, we'll figure it out. But there are several other people here signed up to testify, including John Giannetti, Harold Coleman, Norman Richardson. What? No Norman Richardson. Okay, so again, Antoine Quarles. No. Okay. Kelly Sparks, we're going to continue to keep an eye out for Kelly Sparks. Uh-oh, no? Okay. And then we'll keep an eye, and we'll keep an eye out for Nicole Hansen and MJ Sutton to come across the street. But with that, please, the two of you go right ahead.
Thank you very much, Mr. Chairman, Mr. Vice Chairman, members of the committee. I'm John Giannetti, Jr. for the Maryland Criminal Defense Attorneys Association. I admire what you do. It's been 20 years since I sat on this committee, and I know how hard it is. It seems like a long time. It seems like it went like in a snap. You know, this bill, the Maryland Criminal Defense Attorneys Association saw this bill. Thank you, Delegate Bartlett. Wonderful. We represent criminal defendants. Criminal defendants are the ones that come to criminal defense attorneys and ask for expungements. That's why we're involved with this bill. Right now, you allow a great number of bills to be expunged, a great number of crimes to be expunged. You're saying, let's put ourselves in alignment with the rest of the country. We're at the very bottom of the list. Right? It makes sense. It's not a policy issue as to whether or not these crimes should be expunged. They are expungible. Question is it in earlier time it's appropriate? If that's your decision. We support what the delegate's trying to do. We think it makes sense, and we're here to let you know about it. Thank you.
Good afternoon, members of the committee. I'm here in representation of JOTF, and just tell a short story. It started in '97. I served time. I was released in 2005, and in 2007, I obtained employment at the Maryland Transportation Authority right here at the Bay Bridge, and I've been there since then. And I was released off of supervision in 2009, so I had to take the 15-year waiting period, which won't be up until October the 5th of 2024. And I've maintained my employment, but the problem is I cannot move any further. And I have a lot of opportunities because of the skills I have at working at the bridge to be able to move forward, and I can't because of this waiting period. It's just not allowing me to go into a different department with the state of Maryland. So I want to be, a representation for the people behind me to say that you can make it. It has to be, these waiting periods is just way too long. It doesn't make sense. And we need to have, the law changed so that it does make sense and people can get back into the community and be positive and make others want to do the same thing. We don't want to keep running into the same problem. So I urge a favorable report of this bill. Thank you.
Questions for this panel? Delegate Cardin?
Thank you, Mr. Giannetti. It's always great to see you.
Great to
this
see
is
you.
actually a question for the other gentleman who just testified.
Yes.
But one of the issues, it sounds like, is that you would be a very good risk for somebody to get additional security clearance to be able to move your skills, for example, whether it be in DOT or maybe into Department of General Services and use your skills somewhere else, but you can't because you're being very honest that you have this on your record.
Yes.
And the only thing that's stopping you is this criminal conviction. Is that fair to say?
Yes, absolutely. It's just the waiting period is just too long. It's not allowing me to move forward. You know, I want to be an example.
And there are a number of positions, whether it be with DOT or the Port Authority, that need people with high skills like yours.
Yes.
But they require these certain security clearances, which you just are prohibited from getting until you get this expunged, right?
Absolutely. Excuse me, I didn't mean to cut you off. I'd have probably been a lot further, and I was grateful for the person who gave me the opportunity here at the Bay Bridge. It was an administrator. He's retired now, but it's just limited. I can't go into certain areas.
And you've had no issues or no other involvement with the law since you got this job, and you're doing the best job you can, but you can't move, right?
Exactly.
So this goes to Mr. Giannetti. So given that, is it true that you're I'm lining this up because I know we're going to have opposition, but isn't it true that many of your clients, the clients of your attorneys, see these low-risk people and would love to figure out a way to work with the prosecutors to make sure that they are the ones who are given this ability and to be able to get these high clearance jobs, but the only way to do it is through this tool that we're talking about today?
I'd say that's a fair statement, Delegate, yes.
Okay, because if there's any other way, I'm sure that you would bring it to us, right?
Yes.
Okay. Thank you.
Further questions for the panel? Delegate Conaway.
Chairman, thank you, gentlemen, for coming in and testify. To the gentleman that's waiting to get his record expunged. In all fairness, do you think because you've been walking the fine line that you have a better record now than if you were just in general population?
That's just kind of hard to say.
No,
I mean,
it's not really hard to say. You know what the answer is.
Yes.
But I appreciate your wonderful effort, and I'm very supportive of you getting back to the workforce. Thank you.
Yes. It's been a long time. I haven't been in trouble in a very long time. And
great. That's great. That's great. Thank you.
Yep.
Thank you both very much for your testimony today. That appears to conclude the testimony from those people signed up in favor of the legislation. Very quickly, and just as a little bit of a slight change in pace, question to Delegate Valentine. Is there someone in the audience who you are related to? Or
That's correct, Mr. Chairman.
should we ask her to come up to the witness table and see what would happen next? Or
I would certainly defer to you, Mr. Chairman.
She's apparently refusing to testify. Is there someone you'd like to recognize very quickly before we move on?
Yes, if I could, my better half, my Valentine, my wife, Lisa Valentine.
You don't have to come. That's fine. Don't go there unless you have to. It's fine.
Unless you have favorable testimony.
Okay. You had plenty of witnesses. You don't need more. That's fine. So we have one person signed up in opposition. That's Mr. Cox, who's sitting in the back of the room. John Cox, come on up. And we will hear from you for 2 minutes.
Thank you. So I guess I'm the only thing standing between you and your loved ones, other than Delegate Valentine.
Yeah, no pressure here.
Chair Clippinger, Vice Chair Moon, members of the Judiciary Committee. I'm John Cox. I'm Deputy State's Attorney for Baltimore County and speaking on behalf of the Maryland State's Attorneys Association in opposition to House Bill 97 and ask for an unfavorable report. I hearken back to 2016 when a Herculean effort was taken on by the legislature to recraft the justice system with the Justice Reinvestment Act. And a major part of that was expungement for convictions, which did not exist before that. The expungements were only available for probations before judgment. They went through a long process in finding the crimes that would be eligible and then determining the time period under which a person should wait in order to expunge their record to show that they are going to be law-abiding citizens, and therefore take away from the criminal justice system the knowledge of that conviction. And that's what gets to my point about the time frames. The best circumstance I can give as an example is a theft. So if somebody commits a theft, if for some reason they're not granted probation before judgment, maybe because it was so serious or because they had a prior record, then they have to wait 10 years. Here, this would propose to make that 3 years. And that takes away from the criminal justice system the knowledge of an individual's activities very recently, or relatively recently. So somebody commits a theft and then has a minimal sentence, and then 3 years later they get it expunged, and then the next day they go out and commit another theft. We know nothing about it, and therefore cannot stand up in front of a judge and say he's done this before. That's too short a time period to wait in order to address that. The time periods that were established by the Justice Reinvestment Act are the appropriate time periods, such that the criminal justice system can know of a person's prior activity if they go out and commit another crime.
Thank you very much. Delegate Kaufman, Delegate Young, Delegate Cardin. Delegate Kaufman.
Just very briefly, Mr. Chair. You mentioned that, Mr. Cox, it's very nice to meet you, by the way. You gave the example of somebody gets expunged but then for theft, and then they go out and commit another theft. And I'm just wondering, I mean, because you can always find an unfortunate incident or a horror story to highlight, but do you have any data on how often that happens? Because a lot of the proponents spoke about how they have been on the straight and narrow for years. So do you have any data about how often somebody, gets something expunged and then they go and do the deed again?
Well, I couldn't have data on if they have something expunged because we wouldn't be able to know. So I wouldn't be able to answer that for you. I would cite what was cited to you during the course of the testimony in support, although they believed it to be at least to some degree attributable to the inability to get a job. We heard a lot of statistics about recidivism and the large number of people that do commit another crime. I think the one thing I heard was within 5 years, and that was 64%, I think, for people under the age of 26, if my memory serves. So there is a relatively high recidivism rate for individuals who've been previously convicted of an offense. So clearly that's a circumstance where the system ought to know.
Thank you, sir.
Thank you, Mr. Chair. One might argue that the very fact of the record and the difficulty therein might be a reason for the recidivism. I think some of the folks that testified might say that. But my question to you is this. You mentioned that the JRA, which was a Herculean effort, absolutely, and some of the outcomes therein as it pertained to expungement timelines. Then you mentioned that these timelines are appropriate, but I also heard testimony today that mentioned that we were, or are rather, last in the nation. So my question to you is, given that recognition that we are last in the nation, isn't it true that that might lead us to think that we might not be at an appropriate space? And if so, or rather, regardless of that answer, what would be an appropriate number?
We're not actually last in the nation because at least apparently 7 states don't expunge at all, because they said out of the 43 states that do have expungement.
Recognizing that.
Right. And I'm sorry.
Just want to figure out, like, given that of the 43, we are 43, and 10 years and 15 years is our standard, and you say that 3 might be too low, like, is there a middle ground you might be willing to move to?
Well, one of the points that I didn't have time to address, and it does respond to your question, is that, I mean, when this was presented over on the Senate side, they had that chart up, and I took a picture of it later off of the video feed to try to check on some of that. I just got started on it. I haven't been able to get in great detail. But the one thing I noted was that they said these time frames were for either expungement or sealing. And that actually gets to, and I think, and maybe related to what Delegate Cardin may be about to ask me. There is a difference between expunging and shielding. And I think that's very significant. And it's something that I've voiced to Mr. Dews and others that I'm willing to work with and talk about, because I think there's a big difference between the public having knowledge of somebody's record and therefore affecting employment, and the criminal justice system having knowledge of their record and be able to bring to a judge's attention. And so a lot of, or I don't know a lot of, but at least some of those statutes that have been referenced by the other states apparently refer to sealing, which could very well be what we refer to as shielding.
Right.
I don't know. But I think there is a significant difference there. I looked at, one of the ones that was given to us was Mississippi. And I was stunned at the low time frame that was touted for there. And it's true, there is a low time frame. But it also allows access to law enforcement. So that's not expungement. My concern is with law enforcement and the criminal justice system. I'm not here to speak on behalf of the realtors who don't know that 3.5 years ago somebody stole from their employer if they're looking to employ them.
No, that's helpful. Thank you.
Thank you.
Thank you, and thank you for, you made it a little bit more efficient for me. I was going to ask you about sealing and where you guys stood on that. So that's good to know. That's something maybe that sponsor might want to consider looking at. My other question is really about, it kind of comes back to what I was asking Mr. Giannetti before. The bill proposes 3 years after the end of the probation. Presumably, you could have what's the most probation a judge can give?
In the circuit court, 5 years. In the district court, 3 years.
3 years, right. So in theory, we're talking about, and can a judge give, like, for say, 18 months or 2 years probation instead?
Oh, that's absolutely commonplace. I very often see a year or less. And the other factor, I apologize for stepping on your question, but through justice reinvestment, we built in abatement of probation. So those probation terms, when a judge says 3 years, it's not 3 years. It's ending earlier than that.
Well, is it ending earlier, or is it maybe going from supervised to unsupervised, and then, or is it actually ending earlier?
I hope that I'm not wrong, but my recollection is that it ends. It's abated.
Okay, well, I'll follow up with that, but I
appreciate that.
Okay, so if you're talking about 3 years after a 18-month probation, that's almost 5 years. So if you have a $1,500 theft, which would be, could be, that's a felony, Mr. Chair, that's a felony, is that correct? So you have a $1,500 theft, you've either served time, gotten a conviction, you've served 18 months probation, and now you have to wait 3 years. So that's about 4.5 years that you've waited. You get it expunged. Let's just say you do it again. Where you've basically served your time. You've done your conviction. You did everything you need to do for that 4.5 years. Now you go back and you got to basically go and confront the judge again on the same thing, assuming it's another theft for $1,500, theft over. The state's attorney may not know that he had a prior, presumably, but we're talking about, maybe I'm being a little, it seems like a $1,500 theft. So what that you didn't have you don't have the information about a prior. It seems like you can still manage this pretty well and go about it the same way. And then another 5 years is going to go by before he's able to get that expunged again. I'm not exactly sure why you need to have that knowledge of the subsequent offense on that kind of a conviction to really make a difference as a state's attorney.
Well, I guess we'll just philosophically disagree then, because I would think that it ought to be important to a judge to know that somebody 4.5 years ago did the same thing, as opposed to the impression being that this person has never done anything wrong before in their lives.
Well, so a judge could know now that they'll know the change in the law, so they'll know that it's a possibility that this person, and perhaps there may be some knowledge based on, we just had a hearing, you probably weren't here before, where I asked a person testifying if, what the question is, if he can be questioned as to whether he's been charged with a crime, as opposed to whether he was ever convicted, because when it's expunged, it can be, you don't have to say that you were convicted, but do you still have to answer yes or no, or yes to whether you've been charged with a crime? So, I mean, there's still maybe a way of ascertaining that information, but it seems to me that, I mean, maybe we'll just agree to disagree. Isn't that so?
I don't know. I would hate that a judge is just going to presume that somebody may have had something expunged before in their life. And I doubt that they're going to ask somebody something like that. But yeah, I guess we will have a little bit of philosophical disagreement.
All right. Are there other questions? Sadly, I have a question. The 15 years. What are the other timelines that are going on in the background that, whether it's maybe post-conviction? Am I missing? What is the magic behind the 15-year number? Because that came up in the proponent's testimony, and I feel like there are reasons for it in the law with regard to maybe the post-conviction statute, or I'm trying to remember back to JRA, and I can't remember what the magic was.
I honestly don't know what the magic to the 15 years was. Okay. I mean, that's applicable to a limited number of circumstances, domestic violence, obviously, right, and then the felony offenses, the few felony offenses that are eligible for expungement.
Okay. All right.
My guess is that they chose 10 years for the misdemeanor and thought it ought to be longer for felonies.
For the felonies. And this was some time ago, but while they were, when this was put together, I mean, not that long ago, I guess, but still. All right. Any further questions? I don't see any more. Thank you very much. And that concludes the testimony on House Bill 97.
Thank you.
Miraculously, it is 4:30 and we're done. So thank you all very much to members of the committee. We thank you very much, and we will see you tomorrow.